Court heard appeal in the matter of Cutrale Jr. represented by Mrs. Rosana, Falcioni and another, and Sanches and another.
Mr. Chichari.
I have prepared a speaking note on what I intend to say this morning. I wonder whether, for the sake of efficient progress this morning, I could hand that up.
Yes.
It's effectively a note of what I actually intend to cover this morning. I think it'll save time insofar as looking at some of the bundles may not be necessary, for example, because we can simply see the extracts on paper. So if I may hand that up to the court, this is not
And I can certainly see, given the time constraints, that
Yes.
that makes sense. Has Mr. Kenley had it already?
No, because this is simply a note of what I intend to say. I have not therefore treated it as a skeleton argument.
Yes.
I myself, in fact, only finalised it this morning. But I hope there should be no surprises in there.
Yes.
And obviously, I appreciate if there are surprises, my learned friend will need to have
Protest.
an opportunity to respond.
Yes.
So, my lords, may I start with just a very brief summary of our case on characterisation? I don't wish to re-debate, as it were, the very many topics that we covered on the last occasion, but I just want to give a brief summary of where we say our case lies. Relying on the Sazine principle under Brazilian law, the heirs claim to be the owners of the deceased person's causes of action and to be entitled to sue in their own names in respect of the deceased person's losses. At the characterisation stage, the court is not concerned with the merits of that claim under Brazilian law, nor does it have to assume that Brazilian law is the applicable law. The court is only concerned with the legal nature of the claim, because that is relevant to the real issue of law that is in dispute before the court. The heirs do not claim as representatives of the estates of the deceased persons, but in their personal capacity as the new owners of the deceased person's causes of action, in the same manner that the deceased persons themselves would have claimed had they remained alive. Defendants deny that the heirs have such a personal entitlement and claim that the heirs cannot maintain their suit in their own name and right, but must obtain English grants of representation. Thus, the real issue thrown up by this dispute is whether the heirs are entitled to sue on the deceased person's causes of action in their own names as the owners of those causes of action. The issue is not whether the heirs need English grants of representation or whether they are entitled to administer the assets of the deceased persons, because one, as clearly appears from the claimant names listed in the schedules to the claim form, the heirs do not claim to have been appointed and are not claiming as representatives of the deceased person's estates. And secondly, nor are they purporting to administer the assets of the deceased persons on behalf of their estates. They are simply pursuing the deceased person's causes of action as their own. If, as we contend, the issue is properly characterised as whether the heirs are entitled to sue in their own names as the owners of the deceased person's causes of action, then we respectfully submit that it is then obvious, first, that the correct characterisation of that issue is as an issue of succession to the deceased person's choses in action, to which Dicey's Rule 164 therefore applies, and that applying that rule, the issue of the heir's succession to the deceased person's causes of action is therefore governed by the law of the deceased person's domicile at the time of their death, which on the facts of this case would point to Brazilian law as the applicable law of succession. The real issue, and this is dealing with one of the points raised in argument, the real issue is not merely whether the claimants have title to sue, because first, this would not fully reflect the nature of the heirs' claims as claims in their own names as owners of the causes of action. And secondly, because it is too abstract an identification of the issue to enable a selection of the appropriate conflicts rule, i.e. whether Dicey Rule 164, if the characterisation is succession, or Dicey Rule 158, if the characterisation is administration. It is necessary to identify the basis relied upon by the heirs sufficiently as giving them title to sue to arrive at the real question requiring characterization. And we say that it's important to note that the issue we've identified as the real issue in paragraph 7 is the same whether or not there is a sole heir or multiple heirs of a particular deceased person. The sole heir scenario is instructive because it excludes the possibility that the sole heir represents anyone else beneficially entitled to the estate. Yet the defendant's objection to a sole heir's title to sue is the same as to a co-heir's title to sue, thereby, we say, demonstrating that the real issue for characterization purposes is whether the heirs, whether a sole heir or co-heirs, are entitled to sue on the relevant deceased person's causes of action as the owners of those causes of action, rather than whether the heirs are suing as representatives on behalf of the estate. Then some important considerations in my respectful submission, particularly in response to my Lord Justice Newey's query as to, well, how does one even approach this question of characterization otherwise than by reference to some English notions that are equivalent or at least close to relevant foreign notions. And we say it doesn't matter in the context of the characterization exercise that there are differences between English domestic law notions of succession and administration on the one hand, and the Brazilian civil law notion of seisin, in contrast to what's said by the defendants and was concluded by the judge. And there are really 2 points here. First, the extent of the differences should not be overstated for present purposes, because the legal concept of succession under both English law and Brazilian or civil law relates to the transfer of beneficial ownership of a deceased person's assets to the deceased person's heirs in the case of intestate succession. This is clear under English law, and I've quoted the passage from Cheshire and North on classification or the distinction between succession and administration, which is adopted by the judge at paragraph 189 of her judgment, where succession is described as concerning the substantive rights, such as the beneficial entitlement to the deceased estate. And it is also clear under Brazilian law, as the experts are agreed, that pursuant to the seisin principle, there is a transfer to heirs of assets and rights constituting an estate immediately and automatically upon death. It's not an issue, and I've given you the reference to the joint expert report. Secondly, and this is the critical point that is, in my respectful submission, created confusion or requires to be elucidated, what is different between English law on the one hand and the Brazilian civil law on the other is that under the former, succession is preceded by a stage of administration, whereas under the latter, succession occurs immediately and automatically upon death. So the difference, in my respectful submission, lies in the timing of the transfer of beneficial ownership following death. But the legal substance of what succession is about, namely the transfer of beneficial ownership to the deceased's assets, is the same under both legal systems. And the relevance of this last consideration is that an English court, in our submission, should have no particular difficulty in characterizing an issue as to whether an heir has acquired title to sue on a deceased person's cause of action in the heir's own name and right as being an issue of succession rather than administration. In such circumstances, the heir is asserting a personal rather than representative right to sue on the relevant cause of action, and it would be contrary to the essence of the claim, as well as common sense, to characterize the issue before the court as the heir's purported administration of the deceased person's estate or purported representation of that estate. And that, we say, is effectively why the court in Viegas decided as it did. The Viegas reasoning is sound in principle. It has been referred to with approval more recently by Mrs. Justice Slade in the Haji Ianu case, specifically at paragraph 74 to 78, as noted at paragraph 192 of the judgment. And again, I don't need to take you to that because it's all set out. And the Viegas reasoning is also treated as good law in the textbooks, including in the passages in Cheshire and North, cited at paragraphs 193 and 195 of the judgment. The judge, in our submission, wrongly characterized the real issue between the parties as one of administration. She relied on the fact that the Cézanne principle is not recognized as succession under English law, and consequently felt compelled to conclude that the only relevant characterization was that of administration. That, however, is a non sequitur, because at the anterior stage of characterizing the relevant issue, as consistently held in Macmillan and Raiffeisen, the court is not constrained by purely domestic legal notions of succession and administration, or indeed, I would add, purely domestic legal notions of the timing of succession as distinct from administration. The judge, in our respectful submission, should have focused more closely on identifying the real issue and dispute between the parties. Had she done this, she would have appreciated that that issue was whether the heirs are entitled to sue on the deceased's causes of action in their own names as the new owners of those causes of action. And that issue, we respectfully submit, even by English law standards, as to what succession is, that issue is clearly not an issue of administration. Rather, it relates to whether ownership of the causes of action was effectively transferred to the heirs upon the relevant deaths, so as to entitle the heirs to sue by themselves on those causes of action. And then I address just briefly a number of statements that are made in the skeleton of the defendants in support of the judge's approach. I don't think that I need to take you to the actual passages in the defendant's skeleton, because I think it's fairly clear what the points are. There's a statement that is made in paragraph 30 that a claim is an asset and shows in action, and that is a prelude to the argument based on situs in circumstances where a claim is advanced in England and nowhere else. And we say, obviously, the statement that a claim is an asset and shows in action is plainly right, but that itself does not advance the debate on characterization. A number of statements are then made relating to the situs of shows in action when they are enforced in England. But the considerations of situs that are relied on by the defendants, in our respectful submission, say nothing as to the proper characterization of the issue that arises before the court. And we make three subpoints. First, to make an obvious statement, all claims that are advanced in the English courts are to be, certainly on the defendant's approach, to be treated as situated in England for administration purposes. But that does not of itself explain how the issues that arise before the court in any particular case should be characterized for conflicts of laws purposes. If the issue before the court were correctly characterized as the administration of deceased persons' estates, then the situs of the assets under administration, including assets in the form of shows in action, might be relevant to the scope of the personal representative's power within the administration. The characterization of the relevant issue before the court is an anterior question that is not answered by pointing to the situs of the shows in action. Indeed, if the relevant issue were properly characterized as being one of succession, and Dicey's Rule 164 applied, the lex domiciliae would have been the applicable law even if the deceased person's movables were located outside the country of domicile.
Just pausing there, and I'm really not going to interrupt you more than I really feel I want to. I follow the point you make. Do you dispute the proposition that the cause of action is to be treated as situated here?
No.
Yeah.
No, I don't. I accept that certainly in relation to the claim that is actually advanced in this court against these defendants against whom the court has jurisdiction, that must be so.
Yes, I see.
That is not to say that at a prior point in time, depending upon when the cause of action in fact accrued, that situs may not have been different.
Yes.
That's not your question.
Yes.
I do draw a distinction, for example, here, and again, it's an illustration of the distinction between the anterior question of characterization and the actual application of the relevant conflict rule, whatever it may be found to be once you've characterized, which is the example given by my Lord Justice Nugee of, well, what if a foreign legatee inherits a house that happens to be in England? Surely it's difficult to suppose that that form of ownership could ever be effective unless there's some kind of relevant change on the property register in England. And that sounds right, but as a general proposition. And the reason why that is right, in fact, is because in the case of immovables, the relevant conflict rule in the case of immovables is that the proper law is the lex situs of the relevant immovable. It is not the lex domicilii. But it's different in that case, not because the characterization is not one of succession, but it is because that characterization itself leads to a different conflict rule which points to a different connecting factor.
Yes.
And one mustn't confuse the two.
So you would say if a wealthy Brazilian had a house in London and a car in the garage, as far as the house is concerned, you'd need to apply the English rules. But as far as the car in the garage was concerned, his heirs could claim it as heirs.
Correct. Yes.
Yes.
Of course, I'm not dealing at the moment with questions of proof.
No.
That's a different point, which don't go to the validity of the title, and which, as we know, for example, could give rise to slightly more intricate questions, such as those considered in Chetty and Jennison. But leaving that aside, because the attack here is a fundamental attack as to inherent legal validity of title, rather than, well, you can't quite prove it evidentially. The fifth and the seventh statements that are advanced by the defendants are statements which, in our respectful submission, expose the fallacy or the logical jump in their reasoning, as well as that of the judge, which are statements that proceed on the premise that the heirs advance their claims on behalf of an estate and are purporting to administer the estate of a deceased person, and that the issue of their authority to collect the assets therefore arises. We say that premise is fundamentally flawed. It effectively asserts or assumes the characterization of the issue as being one of administration, but without any explanation of why this is so, and in disregard of the true nature of the heirs' claims as pleaded, as I've already stated. And moreover, the seventh statement in particular is built upon the flawed premise of the earlier statements and assumes that what is an issue is representative title to sue on behalf of and by way of administration of the estate. And the defendant's reference to Jennison in our respectful submission confirms that assumption. By contrast, the title that the heirs rely upon is not representative in nature in this case, but personal title as sole or joint beneficial owners of the deceased person's causes of action. And then more statements are made further on that again build further on that flawed premise as we set out in subparagraph 4 on page 6, so I can skip over that. And then the 10th statement is where they acknowledge and have to contend with the reasoning in Viegas, which they say is an exception to the general rule, but which we say is not in truth an exception to their earlier statements about personal representatives' pursuit of claims as part of the administration of a deceased estate. Viegas was an intrinsically different legal scenario where, like in the present, we say, the claimant was asserting a personal rather than representative title to pursue the relevant claim as the new owner of the claim. And then two final points before I move on to ground 3 that they advance in their skeleton. They say that Rule 30 of the non-contentious probate rules, which provides among one of the categories of person who may apply for a grant, somebody who is beneficially entitled to the estate or to a part of the estate under the relevant law, under the relevant lex domicilii. And they said that, well, the existence of that category and that ability for that kind of person to obtain a grant is inconsistent with our case. We disagree with that. We say that subsection 1b of Rule 30 deals with one of the three categories of person who may be entitled to seek an English grant, where the deceased died domiciled outside England and Wales. But Rule 30 itself is not concerned with characterization issues or conflicts of laws issues. It merely identifies who may seek a grant if they wish to obtain it. And insofar as Rule 30 may be said to make an assumption that a person beneficially entitled to a foreign deceased estate under the lex domicilii may wish to apply for an English grant, that may be so. But that does not entail the conclusion that such a person may not be entitled to assert a legal claim in the English courts in his or her personal capacity, rather than in a representative capacity. Moreover, Rule 30 is not solely or even primarily concerned with grants in connection with choses in action, such as legal claims. It applies to assets generally. There can be many situations where a foreign estate beneficiary, irrespective of its ability to enforce its inherited rights in its own name, may nevertheless wish to secure an English grant in relation to assets located in England. But that doesn't mean that such a beneficiary must necessarily obtain an English grant, irrespective of conflicts of laws considerations. And indeed, we go on to say that Rule 30 itself, which is part of English law, only comes into play if, following proper characterization and application of the relevant conflicts rules, English law is found to be the applicable law. To point, therefore, to the provisions of Rule 30 begs the question of characterization. Final point they make is practical consequences. They say that our characterization produces impractical consequences because it creates substantial uncertainty for an intended claimant. We don't accept that. Dicey Rule 164 is well established. No doubt the identification of the place of domicile of a deceased person may create difficulty in some cases, but that is not the proper basis for questioning the application of the rule in a case such as the present. Even Rule 30, in relation to at least two of the categories of person who may apply for a grant, require the proper identification of the place where the deceased died domiciled. And so the same uncertainty, therefore, that they complain of also affects the issue of grants of representation. But in any event, and perhaps this is the more fundamental point, the one-size-fits-all approach that is suggested by the defendants, i.e. of always having to apply for an English grant of representation as a prerequisite for title to sue, is not one that English law adheres to, even in the limited context of representative standing. Well, not even in the territory of representative standing, but even in the territory of representative standing, as you know, and as we saw from Jennison, different rules apply depending upon whether a personal representative of a deceased estate is an executor under a will or an administrator, and yet further differences exist, at least as regards proof, as distinct from validity of title, depending upon whether the executor is appointed under a domestic will or a foreign will. And the fact that the Sayzine principle is a general principle of civil law jurisdictions is not a reason to ignore its existence when it bears on the characterization of the issue that arises before the court. On the contrary, since considerations of internationalism and comity form an integral part of English characterization principles, it would be quite wrong to ignore the fact that, as a result of Sayzine, heirs from civil law jurisdictions may justifiably claim in their personal right as beneficial owners of the deceased person's causes of action, as Clare decides. So that then takes me to ground 3, which I can take a little more shortly, but which nevertheless does cover some important ground that we need to be clear about. Ground 3 is generally concerned with the nature of an heir's rights under Brazilian law. If we are right about the characterization of the issue of the heir's title to sue in his own name as being one of succession, and that issue is governed by Brazilian law pursuant to Dicey Rule 164 as the lex domicilii, then the judge's own finding of Brazilian law makes clear that heirs are entitled to sue on the deceased person's causes of action in their own names. This is the analysis that you will find in the judgment at paragraphs 200 to 225. And if I can ask you to go to that briefly. So this is core bundle, tab 15. And it's the section essentially that starts under the heading concurrent standing. The introduction is in paragraph 200A, turning then to consider the position under Brazilian law, the issue as to whether heirs can commence proceedings in a personal rather than a representative capacity as a matter of Brazilian law was broken down by the defendants into two sub-issues. There was sub-issue A, which is whether the heirs have standing to commence proceedings on behalf of deceased persons as a matter of Brazilian law, or whether that right was in some way limited depending upon, or restricted, or prohibited depending upon whether there were inventory proceedings and the stage of those proceedings, or whether the heir is only entitled to commence proceedings after transfer of the actual litigation rights as following a sharing. So that was a big part of the trial, that debate, and the experts were not agreed. And the judge deals with the evidence relating to that. And if you look, first of all, she, in the first part of her judgment up to paragraph 210, she says, accordingly, where there was a conflict of evidence in the evidence of two experts, I was inclined to prefer the evidence of Professor Schenck. This was reinforced by the substantive evidence which Mr. Lodicio gave in cross-examination in relation to the cases relied upon by Professor Schenck, which evidence I found inherently unsatisfactory and not persuasive. And then she goes on to criticize Mr. Lodicio's evidence. But for present purposes, the relevant parts of her findings are these. First, at paragraph 214, after referring to various cases, whilst cases do not amount to binding precedent under Brazilian law, the evidence of Professor Schenck was that they were guidance to lower courts and judges, and the cases identified and considered in detail in cross-examination clearly showed multiple instances where heirs had been permitted to bring proceedings in their own right, and clear general statements of the right to do so under Brazilian law. And then at paragraph 222, Professor Schenck's evidence in cross-examination was that the heir does not assume the administration of the estate. These are separate things, which do not exclude the possibility that the heir can bring a claim in his own name. And then quoting from Professor Schenck's evidence, the administration of the inheritance, which is the responsibility of the inventariante, shouldn't get confused, I think is the meaning, shouldn't get confused with the right of the heirs to bring a claim as well. I agree that this is the responsibility of the inventariante, and before assuming this role, the provisional administrator responsible for that. But they are separate things. The list of duties of the inventariante is definitely much wider. What I say in my report is that this duty of the inventariante, which is wider, includes one of the items of the representation in court. But it does not exclude the possibility of the heir to also bring a claim in their own name. It means in respect of their share in the inheritance, their own share in the inheritance. And then if you look at 224 over the page, his evidence, that's the evidence of Professor Schenck, was that there is no reference to the heirs in the administration of the assets, because that is the duty of the inventariante or the administrator. But this cannot be confused with the exercising of the right by the heir of defending in court their own rights, which they have acquired with the inheritance. I accept the evidence of Professor Schenck, which was in my view persuasive, and find that heirs had concurrent standing to bring a claim whilst inventory proceedings are open, and prior to them being opened, and even when closed, prior to the distribution of the assets and the transfer being recorded in the formal de partia. So we said that evidence, which the judge accepted and made findings about, clearly supports the view that under Brazilian law, heirs, if that is the applicable law, heirs are entitled to sue on claims that they have inherited pursuant to the Saysian principle. The judge, however, surprisingly, despite making that finding, did not treat it as sufficient to dispose of the issue. She went on to consider how the heir's right to sue would be characterized under Brazilian law. And this is what she goes on to deal with in paragraphs 226 to 244, especially her conclusion at 244 that the heirs should be seen as bringing their claims on behalf of the estate as a whole, and accordingly this should be characterized as part of the administration of the estate. Now we say this reasoning is misconceived. The hypothesis here is that characterization is an anterior exercise. This is page 9 of my note. The hypothesis here is that characterization is an anterior exercise that has already been carried out, the result of which has resulted in the application of Diocese Rule 164, which in turn has pointed to Brazilian law as the applicable law of succession. The judge was therefore at the stage of the application of Brazilian law as the applicable law of succession. And the only question she should have addressed in that scenario is whether heirs are entitled to sue in their own names under Brazilian law, which, as we've seen earlier, she found that they were, as summarized in paragraph 225 of her judgment. Instead, however, of resting there, the judge appears to have decided to carry out a further characterization exercise, once having done it in accordance with English law, and then again under Brazilian law. And in our submission, having regard to the clear finding at paragraph 225, which the defendants do not dispute on this appeal, the judge ought logically to have held that the heirs are entitled to sue on deceased persons' causes of action in their own names. There was no need for her to go on to consider how the heirs' entitlement would be characterized under Brazilian law. And that was, we respectfully suggest, an error of law on her part. But in any event, if necessary, we do also contend that the judge's Brazilian law characterization of the heirs' exercise of their right to sue as being in the nature of administration was flawed. And that does require a more detailed analysis of her findings. Now, we have dealt with the evidence in some detail in our skeleton. I don't propose, and I haven't got time to go through all of that, but there are some important points that I've brought out in the note that I asked the court to bear in mind. There's first a preliminary issue the defendants have raised as to the standard of appellate review in relation to findings of foreign law. We do not take issue with the principles that are cited from the Privy Council's decision in Perry and Lopag Trust and the Court of Appeal's decision in the Banca Intesa case, as quoted by the defendants. However, those principles nevertheless leave it open to the court, to this court, to find that the judge's conclusion was plainly wrong by reason of her making a finding which has no basis in the evidence or is based on a demonstrable misunderstanding or disregard of the relevant evidence. And that's well established in line with all the case law on the exercise of appellate restraint when reviewing findings of fact, including findings of law. And in essence, we say that the judge has demonstrably misinterpreted the evidence of Professor Schenk, as well as disregarded parts of his evidence that were relevant to the judge's findings. And had she not done so, she would have concluded that the heirs' entitlement to sue in their own names was a substantive personal entitlement that resulted from the operation of the Césine principle and the universal transfer of ownership that occurs automatically and immediately upon death, and constituting all heirs as joint owners of the deceased person's assets. The judge made two critical findings in support of her Brazilian law characterization of heirs' claims as being in the nature of administration. First, she said, at paragraph 243, the heirs are defending the interests of the whole because he does not have an individualized interest. That was the first finding, or the first factor. And secondly, that the proceeds of a successful action would not automatically form part of the estate, but are subject to the distribution process. I think she means, she can't literally have meant the proceeds would not form part of the estate, because clearly they would. I think she meant would not form part of the share that the particular heir might eventually obtain following individualization as part of the sharing process. Now we say, as a matter of analysis, and having regard to Professor Schenk's evidence as a whole, neither of those findings derogated from the heirs' right to sue in their own names as the sole or joint owners of the deceased person causes of action. Sole or joint.
I'm sorry to interrupt.
Yes.
I understand what you say in the case of sole owners. If they're joint owners,
Yes.
as a matter of English law, all joint owners have to join in the claim, don't they? And isn't
Absolutely,
Isn't
and
that
I
a
deal
matter-
with that, if I may, in a moment by reference to authority and CPR 19.3. I think it'll hopefully answer your point, which is that this is a procedural matter.
as a procedural matter, it's a matter for the Lex Fori.
Exactly.
But I understood that you weren't bringing claims on behalf of all the joint heirs, where there are joint heirs, but one or two nominated heirs, on the basis that under Brazilian law, any one heir can bring the claim.
Yes.
But under English law, I'm not sure that's true.
Under English law, you're correct. It's not true in the sense that can I deal with that in a moment, because otherwise
Yes.
I will effectively duplicate my own effort.
Yes,
If I may. But you've raised a relevant point, and I deal with it in a moment. So in terms of the relevant evidence, and I'll take that quite briefly because it's short, but it's really the crux of the matter. The experts were agreed as to the basic effect of the Cézanne principle, namely that it gives rise to a transfer to heirs of the estate assets immediately and automatically upon death. Proposition 1.1 in the joint expert report, not in issue. The consequences of that transfer are expressly set out in 3 key provisions of the Brazilian Civil Code, or requires looking at 3 key provisions, namely Articles 1784, 1791, and 1314, as quoted and explained at paragraphs 14 to 15 and also 28 to 30 of Professor Schenk's report, and which the judge, in fact, relied upon. And perhaps I can show you that evidence so as to set the scene. So this is a supplemental bundle, tab 23. If I could ask you to look at page 345 in particular, where he describes the opening of succession and immediate transmission of rights to the heirs. Paragraph 14. In Brazil, the transfer of the successors of the assets and rights that comprise the inheritance occurs immediately and automatically with the death of its holder, causa mortis succession, which is the very moment the succession is deemed open. Article 1784 of the Civil Code. And if you look at footnote 6, it's actually 5, I believe. Well, footnote 5 first, forgive me. At the bottom of the page, it says in rather small print, once the succession is open, the inheritance is immediately transmitted to the legitimate and testamentary heirs. And that includes for example, pursuant to Article 943, I said in footnote 6, the right to claim compensation and the obligation to pay are transmitted with the inheritance. This is the so-called principle of Cézanne. Its adoption by the Brazilian legal system prevents the existence of patrimony with no holder and the interruption of the chain of ownership. The opening of the succession at the exact moment of death is not to be mistaken for the opening of the inventario. These are different events, as explained later. And then paragraph 15, the inheritance is transferred to the successor as a universal mass of rights in the form of joint ownership, Article 1791, which is quoted in footnote 7. The inheritance is granted as a unitary whole, even if there are several heirs. Sole paragraph, until the distribution, the right of the co-heirs regarding ownership and possession of the inheritance will be indivisible and will be governed by the rules of joint ownership. And then back to the text. Until distribution, the moment at which each heir obtains individualized title to property, all heirs own everything and are submitted to the same rights and obligations as those of joint property owners. Article 1314. And that is quoted in footnote 8. Each joint property owner can use the goods in accordance with its purpose, exercise all rights compatible with the indivisibility, claim it from third parties, defend its possession, and alienate the respective ideal share or encumbrance. So in other words, the ideal share, in other words, a joint owner could seek to deal with its joint share or its share in the undivided whole, but what it can't do, obviously, because it is a joint owner of an as yet undivided whole, is obviously deal with everybody, the property as a whole or anybody else's actual joint share in the as yet undivided property. So that's the, and again, none of this is was actually in dispute, and those basic principles were the basis of all the case law finding from the highest court, the Superior Court of Justice in Brazil, that was referred to under the heading of concurrent standing. Those were the articles and the doctrine that was relied upon by the Superior Court of Justice for saying heirs have the right to sue in their own names by virtue of that right of co-ownership that they have. And if you then look at paragraphs 28 and 29, you will see further elaboration by Professor Schrank of this point. And if you, because he was meeting Mr. Ludicio's suggestion that only the inventariante could take action in court on behalf of the estate. And he makes the point in paragraph 28, second sentence, I understand that heirs have concurrent standing alongside the estate, represented by the provisional administrator or inventariante, to file claims in their own name and to defend the interests of all the inheritance for as long as the distribution is not conducted. Concurrent standing of the heirs encompasses the urgent matters referred to by Mr. Ludicio, but is not limited to them. The position is drawn from a systemic analysis of the several provisions and principles of Brazilian civil law that govern causa mortis succession. As seen in item 5.2 that we saw a moment earlier, the heirs are the true holders of the assets and rights that constitute the inheritance in joint ownership until the distribution. The application of the joint ownership regime to the inheritance ensures to co-heirs the right to use, and then a quotation from Article 1314. As a consequence, the correct position is that until the distribution, an heir has legal standing to file in their own name an action that aims at the defense of the common assets left by the deceased. Although the legal representation of the estate by the inventariante or the provisional administrator is the general rule in Brazilian procedural law, it does not exclude the concurrent legal standing of the heirs. And this is where he diverged in opinion with Mr. Ludicio. And he says, the position defended in the present opinion is well established and supported by cases judged by the Brazilian higher courts. As seen below, there is case law upholding the right of heirs to file a lawsuit in their own name in defense of the interests of the inheritance in both contexts where succession has occurred, but prior to the initiation of the inventario proceeding, and two, where the inventario proceeding is open and ongoing, but the distribution is not concluded. And it also applies, the authorization for concurrent standing also applies to cases of need for a new distribution with respect to the assets and rights that will be part of it. So that was Professor Schrank's evidence, and that is what led to the judge's own finding of heirs having a concurrent standing. And we say that the judge's own key findings, and this is top of page 12 of my notes, the judge's own key findings as to Professor Schrank's evidence are summarized at paragraph 62 of our skeleton, and I think the rest of the analysis I've sufficiently set out in our skeleton. And we say it's important to consider the scenarios where there is a sole heir or where all co-heirs are claimants. I say that because on the facts, there are many instances where the claimants in this case are indeed sole heirs, or where all of the joint heirs of a particular deceased person are claimants. So that it can't be said that there is, as it were, a lack of presence of any relevant co-heir in respect of several of the deceased persons. I don't have the statistics. The court is dealing with points of principle, but I highlight the importance of that particular aspect. But I say it's important to consider the scenarios where there is a sole heir or where all co-heirs are claimants, because they are emblematic of the nature of an heir's right to sue on the relevant cause of action. In those cases, the judge's conclusion that the heirs are to be treated as acting in a representative capacity, we respectfully suggest, is even more untenable. But it's untenable anyhow in relation to any case of co-heirs, because it overlooks the fact that when suing on a deceased person's cause of action, a co-heir is still exercising his or her personal right as co-owner to protect the asset, the undivided, as at that moment, undivided asset in which he or she has a share. The nature of that right is as a personal right of joint ownership is not altered or diminished by the fact that it is a right to a share in an as yet undivided whole, and that a particular co-heir can only practically protect his interests by suing on the entire cause of action, thereby benefiting his co-heirs if the claim succeeds. Nor is it altered or diminished by the fact that where there are several co-heirs, none of them can treat the cause of action as being entirely their own, or seek to dispose of it on their own until formal sharing. The relevant point for present purposes is that it remains a personal rather than representative entitlement to enforce the relevant cause of action. And then I draw an analogy with the English procedural perspective, which is strictly speaking not relevant if you're in the world where Brazilian law applies, but is nevertheless instructive.
Why would it not be relevant? In circumstances where it would then be a procedural question which is governed by the Lex Fori.
You're right. I could see how potentially at the procedural level this issue could become relevant. I accept that. It wouldn't be a basis for strikeout, which is the point that I highlight on the next page.
Yes,
By reference to CPR 19.3, which on its literal terms may not necessarily be that illuminating, but which was the subject of analysis by Mr. Justice Warren in the Yalton and Charles Russell case. I do have a copy of copies of that case. It's a very long judgment, 142 pages. I have it for the sake of completeness, but I've extracted paragraph 249 on CPR 19.3 and its effect.
Could we take it from you at a convenient moment, but a convenient moment is probably lunch rather than now.
Thank you, my lord. So we say English law 2 recognises the personal, and this is a relevant point, English law 2 recognises the personal right of a joint owner to sue for relief to which he may be entitled jointly with others, the only qualification being that all joint owners should be made parties to the claim, either as claimants if they agree, or as defendants if they do not. But a joint owner's personal title to sue is not in doubt as a matter of English law, nor is it, as we've seen, as a matter of Brazilian law. And that takes me to grounds 4 and 5, which I can take very briefly. If we're wrong about grounds 2 and 3, then we'll rely on grounds 4 and 5. And our case under grounds 4 and 5 is explained in sufficient detail at paragraph 79 to 92 of our skeleton. But in short, even if the heirs needed grants of representation in order to bring their claims in our submission should not have been struck out, because they are in a position to obtain the necessary grants pursuant to Rule 31, and thereafter apply to amend under CPR 17.44 to rely on their duly acquired representative capacity if they need it. And the way I propose to address this point is by addressing the points that the defendants have raised, which I think cover the relevant ground in any event. The first point that's been taken against us in relation to this possibility of amendment and of obtaining grants in due course is that they say that there could be no amendment under CPR 17.4 because heirs claims and representative claims are a nullity as a result of being commenced without a grant. So they are relying on the Ingle and Moran line of authority, nullity line of reasoning. But the short answer to that in our submission is that CPR 17.44 was enacted precisely to remedy the injustice that could result from the second strand of the nullity principle established since Ingle and Moran, where the applicable limitation period has expired.
Just pausing there very briefly, I've seen that said, I dare say it's right, but what's the basis for it, apart from it being said? Do we know, is there any learning as to how 17.44
Yes,
came
there
about?
is, and it's in Yogi and Seeley. If I can show you that briefly, the relevant extracts. So this is the Authorities Bundle, tab 46, page 1214. This is a typical case where claim is commenced by someone without proper representative capacity, then representative capacity is obtained later. And there's a question as to whether there can be an amendment. And that was a case under Trinidad and Tobago civil procedural rules, but in the context of addressing the point, the Privy Council examined English law in quite a lot of detail. And the relevant passage starts at paragraph 43 on page 1236. I must now examine in some depth the relevant case law, in particular Ingle, Moran, and Milburn, Snell, and Evans. And I think I can skip over the relevant facts of Ingle and Moran, and you can see that on page 1237 a broad description of the relevant principle, which we saw in the context of ground one in any event, i.e. if you don't have the relevant capacity when you commence the action is a nullity, and thereafter there is nothing to amend and the nullity can't be cured. And in paragraph 45, in the decade following Ingle, there were 3 Court of Appeal decisions on wrongful death which applied Ingle, and those are identified. In each, there had been an alleged wrongfully caused death at work of the person who was intestate, and prior to the grant of administration, a claim was brought by the widow of the deceased. In each case, it was held, applying Ingle, that the proceedings were a nullity because they were commenced prior to the grant of administration, and in each case, the consequence was that the limitation period for an action under the Fatal Accidents Act had expired, so that that action was lost. This drastic consequence of the action being a nullity, which could not be revived by the relation back doctrine, was regretted by the judges, but they considered that there was no route open to them to avoid it. And you can see the various expressions of regret set out on the rest of that page. And then over the page, 46, given the judicial criticism, and this is incidentally the speech of Lord Burrows, with whom Lady Rose agreed. I'll come to the other judges in a moment. Given the judicial, top of page 1239, paragraph 46, given the judicial criticism of the operation of Ingle, where on the facts of Ingle and the other 3 cases referred to above, it would have the drastic effect, when combined with the expiry of the limitation period, of depriving the estate of a claim, it is not surprising that there has been legislative reform in England and Wales to remove that blot upon the administration of the law. The Law Reform Committee, in its 21st report on limitation of actions, recommended that if a party acquired a new capacity, most obviously as in Ingle, where the grant of letters of administration to a party was subsequent to that party's commencement of proceedings, the court could allow an amendment to alter the capacity of that party after the expiry of a limitation period. And then you can see a reference to the insertion of section 35(7) in the 1980 Limitation Act, followed by the promulgation of CPR Rule 17.4 sub 4. And then the Privy Council goes on to say that outside of the scope of the criteria identified in 17.44, the rule in Ingle continues to apply. And then 47, the legislative removal of Ingle in the context of the expiry of a limitation period was referred to by the Court of Appeal in Obiter Dicta and Hack and Singh. And then over the page 1240, towards about 6 or 7 lines down, sentence beginning, but in Obiter Dicta, Lady Justice Arden and Kilje, looking generally at CPR Rule 17.4, made clear that that rule did cover a change of capacity in having later become an administrator on intestacy, but after the expiry of the limitation period, etc. And in fact, if you look at the paragraphs that I've given you references to in my notes, you will see that same point being made repeatedly by all the judges. And the defendant's suggestion is that the lone dissenting obiter comments of Lord Justice Rymer in Milburn and Snell, which is itself, in fact, not based on analysis by his Lord Justice, but on his adoption, as it were, in my respectful submission, uncritical adoption of a comment in Williams on executors, that, oh, well, it can't possibly mean this, is simply doesn't bear much weight, and it certainly can't compete with the numerous dicta by several Lord Justices of Appeal and the Law Lords in Yogi and Seeley to contrary effect. So that was the first point they make. The second point they make is that they say, well, the jurisdiction under CPR 17.4 can only arise if there is an extant application to amend at the time of the order. But we disagree with that. We say that the judge could and should have taken account of the existence and availability of the CPR 17.44 jurisdiction in circumstances where the claimant's stated position is that they would apply under the rule if their appeal on the ground were to fail. And I've given you the relevant evidential references. I don't think there should be any controversy about those. The third argument the defendants have raised is that it cannot be assumed that application for English grants would be successful. But we say that our case is not one of speculative assumption, but of informed assessment based on three facts. First, that each of the three test applications for a grant has successfully resulted in grants being obtained. Two, the fact that all claimants in respect of the heirs claims and representative claims are heirs and are therefore entitled to apply for a grant under Rule 30, Subrule 1b. And three, the fact that the defendants have not articulated, nor has the judge, any positive reason for supposing that grants would be refused if and when applied by the heirs. The fourth point they've raised is that, well, the judge could not conclude that there was a realistic prospect of success for amendment under CPR 17.4 unless the claimants advanced a positive case as to limitation. And the short point here in our respectful submission is that the claimants had advanced a sufficient case in limitation to enable the judge to appreciate the likely fulfillment of the requirements of CPR 17.44. The court has already seen the claimant's pleaded case at paragraph 27.1 of the reply, where at least one effective limitation expiry is 6th of March 2021 in relation to claimants who didn't file a protester, as noted by the judge herself at paragraph 137 of her judgment. An alternative limitation expiry, also relied upon at paragraph 27.1, is based on the interruption of the running of time as a result of the filing of protesters by certain of the claimants between 19th November 2019 and the 5th of March 2020, which is set to restart the 3-year limitation period, so that even on that alternative case, there would be potential alternative limitation expiries between 19th November 2022 and the 5th of March 2024. And so even as at the date of the consequentials hearing before the judge on the 15th of September 2023, those claimants who had filed protesters more than 3 years earlier would have faced a limitation expiry. And so we say in these circumstances, the judge was simply wrong to state that the claimants had not set out a sufficient case as to limitation expiry in connection with the availability of amendment under CPR 17.4. And the fifth point is that they say that the well-established principle that a court should refrain from striking out a pleading before giving a party the opportunity to rectify a defect in the pleading does not apply where the claim is a nullity. Well, we say that obviously ignores CPR 17.44, which curtails the application of the nullity principle where limitation is expired. That being so, it provides an obvious avenue of amendment, which is relevant to the general principle that the court should refuse to strike out pleadings on account of defects which are removable by amendment. And then there's a point they make about, oh, well, you made a tactical choice and, you know, you're stuck with it. And we give some obvious explanations. We have waited to see the outcome from Grant's point. So, my lords, those are my submissions on my grounds of appeal. I do apologise for the speed at which I've been through those points, but I hope they at least illuminate the court a little bit more clearly compared to how I did it, perhaps on the last occasion, when there were wide-ranging questions, so that at least the court is clear as to what our case is.
And I don't detect any more questions, so thank you very much, Mr. Chuchoy. Mr. Kennedy.
Please the court. I'll begin, if I may, then with ground 1 of the claimant's appeal, and I'll take their appeal grounds in order. To recall, ground 1 of the claimant's appeal challenges the judge's conclusion that claims brought in the names of deceased persons are nullities which could not be cured under Rule 17.1. And the claimant's main argument is that they can use CPR 17.1 to substitute a claim brought in the name of a deceased person with the name of another person purporting to act as a representative. And just to remind you how this looks, I'd ask you to look at the core bundle again, and behind tab 22, where you see the claim form. Page 331. go back to the example that you looked at previously, in the middle of the page, number 138, the estate of Sergio Cesar Stamato, represented by Elizabeth Faccio Stamato. And my learned friends already explained to you how those different coloured amendments were added. The problem for the claimants, the fundamental problem, is that amendment by substitution, which is what they seek to do here, presupposes the existence of a valid claim. And these claims, brought as they were originally in the names of deceased persons, were by definition a nullity when they were issued or added. There was nothing to be substituted. And that is a fundamental and very well established principle of English law. The fact that other claims recorded in the claim form are not nullities makes no difference. That does not affect the position. The particular claims brought in the names of deceased persons are nullities. And the focus is on the claim and whether it is a nullity and not on the claim form as a document. The claim form records the several claims. The fact that some claims recorded there are not nullities does not, in my respectful submission, make any difference.
What about the argument that you could treat the existing claimants on other claims as adding rather than substituting, notwithstanding the infelicity of expression?
My lord, that is not what is sought to be done here. If the claimants sought to strike out the claims brought to the name of deceased persons as nullities and add a new claim, we could not take the point that we're currently taking. That is not what they have done. They have done it in some cases, and you see it on the same page, page 331. If you look down about 4 from the bottom, the name of Vicente Somilio has been struck out, and it was open to the claimants then, subject to limitation, in my arguments under Rule 17.22, to add a new claim then. But that's not what's an issue.
I didn't.
I'm so sorry.
This is
on the same page 331 of the claim form.
yes.
And it's the 4th name from the bottom. That's an example of a name being struck out, which is what ought to have been done.
Yes.
And this wasn't an accident, the fact that the claimants seek to substitute rather than remove and replace. The claimants, as I've said before, were well funded and well advised. It's a reasonable inference, I say, that they sought to substitute rather than to remove and add, because they wanted these claims to be treated as having been brought from the date that the claim form was originally issued, to deal with the limitation points that we discussed on the first day. And the learned judge understood this fully. And could I ask you then, please, my lords, to go to the judgment in the core bundle behind tab 15. Same bundle, tab 15, page 235. And under the heading the claimant submissions, I draw your attention to the judge's record of what the claimants submitted at paragraph 143 sub A. There was no doubt that the claimants were arguing for substitution and not simply removing and adding. And that's why they make the point that neither Kimathi nor Jogi was considering substitution under the auspices of 17.1. That was a different point. But the fact that substitution was sought was plainly the case for the judge. And then dropping down to paragraph 144, and rather than take you to the authorities, my lords, I want to take you to the extracts cited by the judge. The judge, paragraph 144, began with Kimathi, where the authorities were summarised, and we see those. I'll just take you to the beginning of the next italicized passage on page 236. My friend has read this to you in full. The key one, of course, is the very first sentence. The first principle is that a claim cannot be brought in the name of a deceased person. And there's authority for this, which dates from at least the early 19th century, Watson and King, 1815. And in fact, the principle is much older than that, if one tracks through the English reports. Dropping down to 145, in Kimathi, the judge rejected the contention that he could exercise his discretion to cure nullity. Quoting from the beginning of paragraph 17, the claimant's alternative submission was that the court has a discretion pursuant to its general case management powers to cure the defect. Dropping down to paragraph 19 in the indented italicized passage, underlined, in my judgment, said the judge in Kimathi, there is no such discretion where the claim is a nullity, as the Moulder and Snell case and the more historic decisions make clear it is. And at 146 on the same page, he notes that Kimathi is approved by the Privy Council in Jogee. Quoting from Jogee now, over the page, second paragraph, in my judgment, there is no such discretion where the claim is a nullity. So this is a quote from Kimathi, when the Lord Burroughs in the Privy Council last italicized passage above 147, Stuart J. regarded it as an untenable argument that Moulder and Snell was decided per incuriam. The Court of Appeal has not considered the application of the overriding objective and CPR Part 3. I agree with Ms. Justice Stewart's analysis. 147, I accept, says our judge, that it could be said to place form over substance, to accept that before the service of the claim, new claimants can be added to the claim form, and the claimants can be substituted, but the claimants cannot be substituted if the original claimant was deceased. However, in my view, the defendants must be correct in their analysis that you cannot substitute a nullity. There is nothing to be substituted. 148. In Jogee, the Privy Council referred to the argument that this approach was overly technical and rejected it as follows, referring to the judgments of the Court of Appeal in Moulder and Snell, and concluding that the common law rule can be defended in that requiring the appropriate person, i.e. the administrator, to commence proceedings ensures, said the Privy Council in Jogee, orderly proceedings, avoids duplication, and means that the estate is represented by the most appropriate person. In other words, if you go ahead, please, to paragraph 152 on page 239 now. The fact pattern in Kimathi was that a claim had been brought in the name of a deceased claimant, and thus was not a case where the claim was maintained by the same person. The judge held the claim was a nullity. In my view, his conclusion in this regard was not challenged by the Privy Council in Jogee, and the Privy Council is clear that a claim which is a nullity cannot be revived or cured. And to go to the judge's conclusion at 159 on page 241. Further, even if the claimants in question who were substituted could have been validly added, this is to my Lord, but Justice Lewis's point to me this morning, could have been validly added under CPR 17.1, this was not what was done. And even though this may appear to place form over substance in the light of the authorities, the legal characterization is different and results in different legal consequences, which is why the judge reaches the conclusion in paragraph 160. Turning then to the claimant's submissions, the first...
Sorry, just pausing there one moment. In what respects would the legal consequences be different?
If the administrator was to strike out the name of the deceased person, recognising its nullity, and then add the name of someone who had a valid claim, which could be done to 17.1, subject 17.2, it could be done to 17.1, then there'd be no question of the new claim being a nullity. Because it wouldn't be, it would not be seeking to substitute the claim which was a nullity. It would be bringing a fresh claim by a representative in respect of damage suffered by the estate.
I'm probably being obtuse. I'm not quite clear. I've got in my mind why addition rather than substitution would result in different consequences.
The consequence would be limitation, my lord. I think that's the point. If it's substitution, then if it could be substituted, it would take its time from the would have a relation back and would piggyback upon wouldn't need relation back, would piggyback on the original claim and would be timed from its first issue. A brand new claim then would have to have different limitation consequences. Which is why I said in opening, this we say was done deliberately. It was in order to obtain a limitation advantage.
But if we were to recharacterise what happened, we see what was done and said, but we were to say, in substance, this was seeking to add somebody, whether they should have done it more clearly and not put in further words, neither here nor there, but the aim was to enable somebody to bring a claim who had not hitherto brought it. There wouldn't, and we treated it as addition, there wouldn't be limitation consequences, would there?
But that, if it could be recharacterised
Yeah.
in that way, but in my submission that would be an inappropriate and impermissible characterisation, because what my lords have seen as clearly as anything in the claim form is that what is sought to be done is substitution, and the claimants were absolutely clear before the judge that what they sought to do was not to remove and add, but to substitute.
Okay, there's a question of what was actually done as a matter of fact, and the consequences follow from that.
Indeed.
And we shouldn't try and be kind and bend over backwards to save things.
Indeed, and the reason is because this is a question of substance. This is not a procedural defect which the court ought to cure under the overriding objective. Whether something is a nullity is a question of substance, and these are property rights. And so the court should resist the natural tendency to seek to cure what might seem to be a technical problem. It's much more serious. It's a nullity and a question of substance. So, yes, of course. And Ms. Luckhurst reminds me, and of course, if my lords are against my submission, and you were to treat it as an addition, I would make all the points that I made in my own grounds of appeal in relation to the operation of relation back
Yes,
and Rule 17.22.
yes.
But I hope we don't get there because of the very important points of principle which should not be brushed aside and in order to give the claimants what they need. On the claimant submissions themselves, the first point was that this was a victory of form over substance. I think I've addressed that in the submissions I've made to my lords. The second point is that CPR 17.11 should be interpreted to permit substitutions of the present kind because a defendant would not be substantially disadvantaged by such an amendment. But that really is the same as saying if we had done it the right way, the defendant would be in the same position as he would be if you cured this nullity now. And that, in my respectful submission, is a thin basis to set aside more than 200 years of fundamental jurisprudence in this jurisdiction. And there's nothing in the language of 17.1 that expressly or impliedly permits the substitution of a claim that is a nullity. The third point the claimants make is that Kamathi and Jogi are irrelevant because they concern post-service amendments, and that's also wrong, as my lords have seen. Those authorities don't turn on whether amendments were made post or pre-service. They confirm the more fundamental principle to which I've drawn your attention. They weren't concerned with 17.1, true, but the point, the fundamental point is the same, that the claims are nullities and the CPR rules cannot be used to override that. And the point I made to my lord about the distinction between substance and procedure was noted by Mr. Justice Stewart in Kamathi, paragraph 18, my lord's note. And those, my lords, are my submissions on the claimant's ground 1.
Yep.
Move on, if I may, to ground, and before I move on to ground 2, because the morning is so long, the shorthand writer will need a break, and I'm in your hands as to when.
Should we do that at, say, past?
I'm obliged.
So quarter of an hour's time.
So on ground 2, the claimants challenge the judge's conclusion that the applicable law governing right to sue was English law. And the judge did so because she characterised the issue as one concerning the administration of the state of the deceased person. Now, by ground 3, the claimants challenged the judge's conclusion that even if the applicable law were Brazilian law, the issue would still be characterised as concerning administration.
I'm not quite sure how that plays out, but perhaps we'll explore that when we get to ground 3.
Straight away, because the claimants have rather conflated the points. The judge's starting point was, now, the issue is title to sue in England in respect of loss or damage suffered by a deceased person. She found, as a matter of the law, Lex Fori, England and Wales, that was to be characterised as a matter of administration, not succession. But if she was to look at it through the Brazilian law lens, whether it was a question of administration or succession, this is ground 3, she still found that looking at how things are treated in Brazil under Brazilian law, it is still a question of administration from an English law perspective. That what is happening in Brazil is regarded by us, applying our law and our approach, as a question of administration, not succession.
Can I just, perhaps by reference to Mr. Chuchoy's speaking note this morning, understand where the differences are? He comes onto this on page 9 of the note.
Miles, I must say, I didn't want to waste time complaining about this 16-page skeleton argument, but I haven't had a chance to read it.
No, all right.
But Michael, I'm happy to be drawn to it, but I can't answer your question.
One point he makes early on is that there was no question of double characterisation. You characterise according to English law. Who cares about characterisation in Brazilian terms? Now, do you accept that?
So is Moulder saying that was my learned friend's point?
Right? I think he says that. Maybe
I
I'm wrong.
struggled here.
Maybe that's your point. At any rate, I don't quite understand. Wrapped up in ground 3, as presented a moment ago, seem to be 2 points. One is as to what Brazilian law is,
Yes.
and doubtless you'll come on to that. Another is, well, how do you characterise once you know what Brazilian law is? Now, as you say, the authorities suggest that you characterise by reference to the law of this jurisdiction. So I'm not quite sure where characterisation comes into it.
Characterisation comes in at the very beginning under ground 2.
I follow that.
And in ground 2, one applies the lex fori to the issue between the parties, and in order to characterise it, in order to work out what is the real issue. And at that characterisation stage, the judge simply asked, what was the question? The question was, do these people have title to sue in England in respect of loss and damage suffered by a deceased? And presented like that, they said, as a matter of the lex fori, that is a question of administration, not succession. And we'll see that in Genesis, and we'll come on to that. Because it's a representative matter. They don't hold that the people who are suing are collecting in assets for the estate. They're not
And
suing
I
in
follow
their
on
own
that.
right.
We're going to come to that. Can I go to paragraph 24 of Mr. Chuchoy's note?
That was before I got on to Brazilian law, that was all just looking at English law.
Yes.
Paragraph 24, yes.
So he says, well, in 24.1, characterisation is an anterior exercise, and once you've done it, you apply Brazilian law if you conclude that you characterise as a question of succession, and then you simply apply Brazilian law. Now, do you quarrel with that? Suppose it's ground 2, you have characterised this question as one of succession. Why isn't that effectively the end of it? Because then you say, well, under Brazilian law, they can sue.
Yes, if the first question is one starts with the issue, which is the same issue, if I may say so, identified by Lord Lewis and Lord Nugee, which is, do the claimants have title to sue in England in respect to loss and damage suffered by a deceased? And if the judge on the pleadings identified it as a succession issue, by the lex fori, then it would be the lex domicili that would be applied, and the judge would go on immediately to apply the lex of the domicili. If it were a succession issue, applying the lex fori.
Absolutely.
So is the judge asking, I mean, in a sense, we're asking what question should the judge have asked? And in a way, whichever of the two questions you ask would dictate the answer. Is the question, do these people have title to sue? Answer under English law, lex fori, it would be those with administration. If you ask a different question, who has inherited these rights? Would thereafter be a different? Well, no, you say, even if you ask the question, who has inherited these rights?
But that still doesn't answer the question as to whether this is a question of administration or succession.
No, exactly. That's the first question. Who has inherited these rights? And the answer is it may be complicated under Brazilian law because they may have standing to sue, but not actually have. That's your argument.
Exactly. Because if the issue is who has title to, whether these claimants have title to sue in England in respect to loss and damage suffered by deceased, the fact that they may have inherited collectively the rights in Brazil does not tell you that it's a question of succession.
It's more than that. They have inherited the rights in Brazil and they have standing to sue for those rights.
Indeed.
But you would say because it's standing to sue for collective rights,
yes,
it's still administration. Yes. Is that it?
Yes, and I'll just quickly check and make sure I haven't. So Mr. Usher wants me to add that what the claimant's submission boils down to is they say we have the right to bring these claims in Brazil. We have authority to bring them in Brazil even before the sharing. And the answer to that is, as a matter of the lex fori, as a matter of the law here, that does not determine the question of whether this is administration or succession. Because as I'll show you in a moment in our system, as summarised in Dicey, the fact that someone has authority to sue in what we would characterise as a representative capacity in a foreign country is nothing to the point. If the true nature of the claim is representative, they need a grant in England.
And I follow that. Can I just take you back to paragraph 24, just to understand whether you disagree with Mr. Chuchoy on this? Perhaps if we skip over the opening words, Mr. Chuchoy says the hypothesis is that characterization is an anterior exercise that has already been carried out, the result of which has resulted in the application of Dicey Rule 164, which has pointed to Brazilian law as the applicable law of succession. The judge was therefore at the stage of the application of Brazilian law as the applicable law of succession, and the only question she should have addressed in that scenario is whether heirs are entitled to sue in their own names under Brazilian law. Instead, however, the judge appears to have decided to carry out the characterization exercise twice, once in accordance with English law and then again under Brazilian law. Now, do you quarrel with that? I mean, ground 2 is characterization.
Yes.
You say it's not succession. But supposing that at ground 2 you decided it was a matter of succession, well, why don't you just apply Brazilian law?
One second. My lords, we do take issue with this, obviously, and as we'll explain, ground 2 is, my lords, quite right. The first stage is characterization, and one asks, what is the issue, and then whether it's administration or succession under lex fori. If, as I just said a moment ago, if in characterizing the issue, the judge went on to say this is a question of succession, under our approach, she would apply Brazilian law, and then she would go on in round 3 to ask, what does Brazilian law say about title to sue?
Yes.
It would still be necessary to ask what Brazilian law says. That's
yes.
An analysis that has to be undertaken.
But that wouldn't be a characterization question.
No, in those circumstances, she would not be characterizing Brazilian law, she would be establishing it. But here, the learned judge characterised the issue as I've described, and she asked whether it was a question of administration or succession. And she looked at it through two lenses. She looked at it through the question of English law, and then she asked whether, under Brazilian law, it made any difference. Whether, looking at how things are done in Brazil, would we treat this as administration or succession? It was never in dispute that in Brazil, the principle of suzerain works and the heirs inherit collectively at the point of death. That was nothing to the point. The question was, what is the nature of the Brazilian process before the sharing, and is that something we would understand as administration or succession? And she took that into account in the alternative for the purpose of characterization. And perhaps that's the answer. She took one approach and then said, in the alternative, if I am supposed to look at the Brazilian approach, I find there's no difference.
But the difficulty with that is, the first question is, do you call it who's got title to see, or do we say it's succession? And if the answer is no, this is a question of succession, that should be the end of it. Under Brazilian law, these people have succeeded and can sue. But what you're saying is you do another analysis, and the law in Brazil is a bit more complicated than that. And even though it's succession, it's, if you like, a two-stage succession. Yes, they can bring an action, but no, they can't actually get any money yet until they've got the distribution. And you're saying because of the problems under the law of succession, with its two-stage process, I'll relate that back to the first question I asked and say it's therefore really, even under Brazilian law, the succession is akin to administration. But why can you do that, having gone down the route of succession, and even if you don't feel it's terribly satisfactory, how can you import it back is the problematic issue.
Well, perhaps I'll go to the authorities, but just to, that may cast some more light. But the point, the issue is, as I've described now twice. The question then is administration or succession, applying the lex fori. The asset is in England. The gathering in is in England. It's being collected here. That means we're concerned with administration in England, and applying the authorities, that tells you that it's English law that determines the authority to bring the claim. Title to sue is governed by English law, and English law says that has to be given by a grant, and foreign authority or foreign grant is no good, subject to applying under the non-contentious probate rules. Then she was asked to look at Brazilian law, and she said in the alternative, I look at Brazilian law and ask, is the treatment of it any different? And in Brazil, it is also characterized as administration.
Why do you say that? Well, I don't quite follow that point, but just before we go there, if we go to paragraph 244 of the judge's judgment, which I think is supposed to give rise to the alternative basis for the decision.
Page 244.
No, sorry, paragraph 244.
Thank you.
So paragraph 244 opens, even if under English conflicts law, Brazilian law is the most appropriate law, it doesn't alter the conclusion on the characterization. Now, what does that mean?
It's if, as she was being urged, she was to characterize the issue here by reference to Brazilian law.
What do you mean by reference? We've characterized as under English law as succession. So that Brazilian law is the one that is the most appropriate and is to be applied. Well, isn't that?
The difficulty here is that, of course, my submission before the judge was that it was appropriate to look at what suzerain actually involved, and that was in any view not succession, and that was sufficient for the purposes of determining the whole point. She went into Brazilian law in more detail. She was invited to do so to see if it made a difference. She found it didn't, and which is why the grounds are split between 2 and 3. And all I can say at this stage, looking at the clock,
Yes.
is this, that she was taking the lead from the learned friends in order to take an internationalist view of characterization. and to that extent was looking at Brazilian law to see if her first approach to characterization offended against Brazilian law in some way or was offensive to principles of comity. And then she went on to look at what Brazilian law did, but always applying the lex fori, always asking if, since the issue is, do these claimants have title to sue in England and Wales in respect of loss and damage suffered by a deceased person, is what is happening in Brazil understood by us as administration or succession. And that was certainly correct. Even if the route she took to it might have been circuitous, the core analysis is, in my respectful submission, fundamentally right. And the alternative, urged by my friend, is fundamentally wrong. The thrust of his submission was just go straight to, because we say it's succession in Brazil, that's characterization done and dusted, and you go straight to Brazilian law, and that's all you need. And whatever else, my lords, that is definitely wrong. But I think that's an appropriate moment.
Yeah.
Rise if able. Please be aware that the live stream is still running, so if you do want to discuss the case, you can either do it really, really silently.
Thank you.
That means she's assuming, because the only way she's assuming is that she doesn't want to ask the succession issue. Yeah. Assuming it is a succession issue. Then I ask, well, say it's a say it's a succession issue. Simply means you need to look at what was in the I'm quite good. The question is, do they actually have that by distribution to them? Do they have the question? Which comes back to this important. And then you say, that's what demonstrations. And the way you test it is by looking at the Brazilian process.
issue is. First step actually is ask yourself what's the question.
Yeah.
Second stage is look at the connection. What arguments do I? Saying she's student do because she's right, he's right in the sense that there are stage one. So most of the client or characterization, she is asking herself, do they have to have they succeeded to these points?
Yeah.
Is that the issue between is this an issue of succession?
Yeah.
Have they succeeded? Now we accept ground 2 and ground 3 overlap to the extent that in both stages you're asking yourself,
Yeah.
have they succeeded to the relevant courses of action? And from our perspective, as I said, we're not fussed about whether or not. But the key point is the judge hearing the experts said they did not succeed.
Whether you can.
That has to be judged by the English concepts of registration and succession because it's in the next order. So you can look at what Brazilian says about it. She doesn't say that.
Authorise if able.
Mr. Kennedy.
I'll try and answer my lord's question very briefly, and then I will move on.
I think you probably should move on and come back to us in due course.
I'll deal with it now if I may, and if my answer isn't satisfactory, hopefully it will become clearer as I go through the authorities. The starting point is characterization, which is always a matter of the lex fori. The judge began by describing the issue, which I've described to you already, title to sue in England in respect of loss and damage suffered by a deceased. It's the first part of the Macmillan test. And then she asked, what is the connecting factor? And there were two possible connecting factors, succession or administration. And her starting point, which is covered by ground 2, was to ask whether the heirs had rights distributed to them, because as a matter of English law, distribution is key. And so, applying English law, she said this was a question of administration. Full stop. Then she said, if alternatively, this is to be characterized as an issue of succession, you still have to ask, have they in fact succeeded? So even if it's an issue of succession, the court has to ask whether they have succeeded to the rights. And because it's an issue of succession, she looked to Brazilian law and asked if they have succeeded to the rights in Brazilian law. And she found, as a matter of Brazilian law, that they don't succeed to the claims in a personal, exclusive sense until the formel de partilha. And so she said, even looking at this as an issue of succession, I still come back to the connecting factor as an English administration. This is an administration issue in England. But, my lords, even if the court finds that the judge's approach was, in this respect, wrong or complicated or unnecessarily complicated, from our perspective, it doesn't matter whether we recognize that grounds 2 and 3 are very closely linked. And the correct approach, I hope, is the one I'll proceed to set out to you by reference to the authorities. And if the court wishes to follow that, that's a perfectly appropriate approach open to you. The result will be the same. So as I've said now many times, the issue before the court, as you've suggested in argument, was what is the law governing title to sue in England in respect of loss and damage allegedly suffered by a deceased person. I've already addressed the two ways in which the judge could characterize the issue, and she found it was a matter of administration. Why? First, the claimant's claim in this court is a shows in action, an asset of the deceased person, which he could have sought to realize during his lifetime by bringing a claim. My learned friend did not dispute that. Second, that shows in action, that right to claim against defendants in the English and Welsh courts is situated here once the claim is brought. That's because the claimant has chosen to seek to realise the asset in England through the courts of England and Wales by seeking to convert it into a judgment debt. It is reduced to possession here and is situated here. Third, as a matter of the law of England and Wales, any assets of the deceased person situated in England, including claims that the deceased did not litigate in his lifetime, devolve upon the personal representative of the deceased. Any claim that the deceased person could have brought in his own name during his lifetime falls to be pursued by the personal representative of that deceased person. And finally, making a claim on behalf of the estate is part of the gathering in or collection of the assets of the estate and is therefore part of the administration. And it's common ground that if these claims are to be pursued as part of the administration of the assets of the deceased, there is no title to sue without English grants representation. The claimant's argument, as you've heard, is that it was not an issue of administration because the relevant claimants had succeeded to the claims in their own right under the Sazine principle. And the thread running through their argument is that there is no distinction between administration and succession under Brazilian law, and that Brazilian law does not even recognize the concept of an estate. None of that is correct, even as a matter of Brazilian law, as the judge found. But even on the materials shown to the court by my friend, under the Sazine principle, the assets of the deceased person are treated as having been transferred immediately to heirs collectively upon the death of the deceased person. But that is not succession, as we understand it here, which is the lex fori. Under the Sazine principle, no individual heir owns any particular asset of the deceased person. No heir has an absolute entitlement to anything, to the exclusion of all the other heirs' interests. It may be that the heir never gets to own anything personally. And this is true even for a sole heir. Any creditors, any claims the revenue has upon the estate must be paid first. This is a common ground before the judge on the Brazilian law. And the judge found that the sole heir also needs the formal de partia, the sharing process is still required. The distribution of assets to individual heirs occurs at a later stage, that is the sharing. Individual assets are distributed to those entitled, even as I said, where there is a sole heir, using the formal de partia, which records who gets what. Until that point, a particular heir may get nothing. And the point that we've made is that both in Brazilian and English law, a distinction is made between administration and succession. A period after the death of the deceased person, but before the assets of that deceased person are distributed, is administration. And the point at which those assets are distributed, that is succession. But that is not what happens under Brazilian law pursuant to the principle of Sazine, as is common ground. And so we say the Sazine principle does not amount to succession under English law because of itself it confers no absolute entitlement to any specific assets. And to take up the point made by our friend this morning, when he asks, what is the true nature of the heirs' claims, as the judge found correctly, the true nature of the heirs' claims, although brought in their own names, is they are claims in the administration of the deceased's estate. From the point of view of English law, until the formal de partia is issued, we are still concerned with the administration of the estate.
Do we have any evidence as to whether the forma de partia was issued in any of these estates? What's the position?
No, there's no evidence. There's no evidence that we've seen that the claims that are sought to be pursued here were issued to anyone, according to formal de partia in Brazil.
There isn't a sort of sweep-up clause at the end. I can well understand, but until this claim's been brought, nobody in Brazil would identify it as an asset. But what happens to an asset that's not been identified when a forma de partia?
That we can find. The Brazilian rules provide for a hierarchy of claimants in the distribution of assets, and we will. My colleagues will see if they can find an answer to my lord's question. I haven't got one right now. But the point is that it's not been suggested that these claimants have been distributed the claims under the formal de partia and are suing in that right as persons to whom these rights have been distributed under the formal de partia. My own friend's point is that that's all by the by. Yes. They have the right to be here from the moment the deceased passed away. I'm not going to go back to Macmillan in the time available. I think
and just for completeness, you've told us a moment ago that the evidence shows that even in the case of a sole heir, there has to be the sharing stage and so on.
Yes.
At some point, I wouldn't mind the references for that.
That's because this point is taken, that's in the consequentials judgment. Tab 16, page 260. Shall I show it to you right now, since you asked? It's in the court one. Tab 16, page 268. This is a point taken by my friends at the consequentials stage. And if you go to paragraph 19, page 268, it was said by the claimants that where there are sole heirs, the heir has stepped into the shoes of the deceased under the law of domicile. In paragraph 20, it was said that so these are further submissions that the claimants make. But halfway through paragraph 20, if a claim is brought by a sole heir, the entitlement is absolute. They were eliding, they said there was no distinction between sole heirs and all heirs, but they refer to sole heirs here. And then the defendant's submissions are recorded. In paragraph 23, the judge repeats the conclusion she reached in the main judgment. And in paragraph 24, she said, in my view, it makes no difference that the persons entitled are solely entitled, or that all heirs together bring the claim. There is no difference logically from relying on the principle of sezine. The authorities are clear. It doesn't affect the need for an English grant to administer the estate. And then applying the primary findings of the judgment on this issue, the claims are brought by heirs, whether sole or jointly, prior to transfer and recording the formality party. There was no evidence before her that a sole heir did not require a formality partia. And all of the evidence before her was that in all circumstances, a formality partia was required. And one can see right away why that would be the case. Even if there's a sole heir, the sole heir may get nothing once the liabilities of the estate are paid off and the revenue, whoever else needs to be paid off. And so the sharing process logically would be required even if it was a sole heir. As I said, my lords are very familiar with the principles in Macmillan. The point I wish to take from it is the one in Lord Justice Old's judgment that characterization is with X 4I. I've taken too long on that already. But moving on then to how those principles are applied when a claim is made in respect of loss of damage suffered. A deceased person, please turn up Dicey. That's in the 4th volume of Authorities. Tab 62. I'll begin with Citus. Page 1624. Page 1624, that's rule 136. And as my friend accepted this morning, he doesn't dispute that a cause of action is a chosen action. And the site of the things is determined as follows, says Dicey: shows an action generally are situated in the country where they are properly recoverable or can be enforced. And next, please, could you go to page 1627? Rule 156 at the bottom of the page. The following property of a deceased person vests automatically in his or her personal representative by virtue of an English grant. 1. Any property of the deceased, which at the time of his or her death is locally situated in England. And over the page, the note at 27, paragraph 27, 022, all property of the deceased, movables or immovables, which at the time of his or death is locally situated in England, vests in the English personal representative. It is not necessary that he or she should have reduced the property into possession. And skipping down to the next sentence, whether or not he or she is entitled to recover them is a matter for the law of the country in which they are situate. So the question of title to sue is a matter for the law of the country in which the assets are situate. And if you go please now to page 1629, law governing administration, the administration is rule 158. The administration of a deceased person's assets is governed wholly by the law of the country from which the personal representative derives his or her authority to claim. And skipping down, please, to 2732, the final paragraph on that page. Administration within the meaning of this rule does not include the distribution to beneficiaries of that portion of the assets which remains in the hands of the personal representatives after the estate has been cleared. This is characterized as succession. It's governed by different rules. And next, please, Rule 159 on page 1631. And this goes to the point my learned friend has been making repeatedly, and it is the answer to it. Rule 159, a grant of representation or other authority to represent a deceased person under the law of a foreign country has no operation in England. So under Brazilian law, the claimants could have authority to sue in respect of damage suffered by the deceased. But that has no operation here if the claim is representative in nature, which the judge found correctly it was. I could ask the court now please to go to tab 65 in this volume, and Williams, Mortimer, and Sanches on executors, and paragraph 3.01 on page 1639. Second half of that paragraph 301, it is important to distinguish two concepts, administration and succession. In broad terms, administration concerns the making of grants of representation. And I rely on this, the collection of the deceased's real and personal estate and payment of the deceased's liabilities. Succession concerns the beneficial entitlement to and distribution of the deceased's estate after discharge of his or her liabilities. The law governing one may not govern the other. If we could move on, please, to Jennison and Jennison, where these authorities, these principles were applied.
So another way then of characterising it from your submission is that there's the gathering in of the harvest and the divvying it up. The administration gathers everything up to distribution, and distribution is sharing it out.
Yes, yes, exactly.
Sorry, you wanted?
Jennison and Jennison. I appreciate that my lawyers have seen this judgment already, but it is important on this point. And I'd ask you to go back to it. It's in the authorities bundle behind tab 53. That's volume 4. And could you go please to page 1427. No doubt the court recalls the broad facts about the deceased. You see this at paragraph 1 and 4. I'm not going to read them to you, but the deceased left a will, appointed the claimant as his sole executrix. Proceedings were issued in England in February 2019, claiming as the personal representative, but you didn't obtain a grant until November 2019. And the defendants made the point, you see this in paragraph 7 over the page, that she has no standing to bring the claim when it was issued. And if you go on please to page 1429 in paragraph 15, paragraph 15, my lord made the point that as a matter of domestic law, an executor is considered to gain title as soon as the testator dies, but administrator acquires title only when letters of administration are granted. And then if you skip ahead, please, to paragraph 19 on page 1430. In the case of a person domiciled abroad, the law of the domicile will apply in relation to various matters affecting the distribution of his estate. And the word distribution there is critical in this issue. But moving on, now please, to paragraph paragraph 20 before is the same point you've seen in DICMR 159. I'll move on, please, to paragraph 31. The significance of Chetty and Chetty. It's the claimant's case that the respondent's appeal should be dismissed, even if the resealing does not have retrospective effect. The claimant's counsel argued that the claimant derived her title against the defendants from the deceased's will, not from the resealing of the grant, reflecting the distinction between title to sue under a will and title to sue in an administration referred to by my lord. The claimant needed either to have the grant resealed or to have done to grant of probate in this jurisdiction in advance of trial, only that she could prove her title. But having been named as the deceased's executor in his will, the claimant acquired title on death. And she relied on, in support of that submission, on Chetty and Chetty, where in Chetty and Chetty, the executor didn't obtain probate until 1912, but proceedings had been issued in 1911, and the same point would be taken there. And sticking with paragraph 32 over the page, the Privy Council applied the principle that an executor derives his title and authority from the will and not from any grant of probate. So the fact that the grant came after the issue of proceedings did not invalidate it. And at paragraph 33, counsel for Ms. Jennison made the point that the present case is analogous. Like the executor in Chetty, the claimant derives her title from the deceased's will, and so she already had standing when the claim was issued in February 2019. We go on, please, to 1439. In paragraph 42, the claimant in this case, Jennison, was still not out of the woods because New South Wales law was not identical to English law. And if you see at paragraph 43, between the two hole punches, is a reference to the New South Wales Act, section 61, that says that from and after the decease of any person dying testate or intestate, and until probate or administration, or in order to collect is granted, the real and personal estate of such deceased person shall be deemed to be vested in the New South Wales trustee in the same manner, to the same extent as aforetime. The personal estate in effect vested in the ordinary in England. And the implications of that were considered in an Australian case, Byers, and the headline from Byers, you can see at the top of page 1440. Ms. Byers had no title to the relevant shows in action until the grant of probate. The defendant's argument, Jennison, was the same as the argument the claimants make here to this extent. The defendant's argument in Jennison was title to sue is governed by the law of the deceased's domicile, and not by English law. And if you apply the law of the deceased domicile in Jennison, the claimant doesn't have title to sue because she issued before she got probate. And that is the claimants in this case also say the title to sue is governed by the law of the domicile. That point was rejected by the Court of Appeal in Jennison. And we see my lord approached it at paragraph 1441. Paragraph 48. And the heading is the Chetty and Chetty approach of general application? My learned friends and their skeletons seek to limit the implications of this, but I do rely on the words general application in the heading of the section that follows. And before we read paragraph 48, it's an interesting passage because the court will recall from the claimant's skeleton their submission that it would be perverse to have a situation where, until the formel de partie is granted in Brazil, different people could have title to sue at the same time. In Brazil, the heirs could sue, says my learned friend, without further procedural obstacle. But in England, there would have to be a personal representative with a grant. And that personal representative would cease to have title when the heir receives the claim under the formality partia. And so you could have the situation where two people could sue under two different legal systems at the same time. But a very similar problem or situation arose in Jennison and did not deter the court. It's plain if the Chetty and Chetty approach is applied in relation to the will of the testator who is domiciled in New South Wales, a court in this jurisdiction would potentially treat an executor as having title to the estate when a New South Wales court would not. And as counsel accepted, on her case, the claimant could have issued her claim in England before obtaining a grant of probate in New South Wales, and hence at the time when, under New South Wales law, the deceased's estate was vested not in her, but in the New South Wales trustee in accordance with Section 61 of the New South Wales Act. The claimant would have needed to be in a position to prove her title by the time the case came on for trial by means of either an English grant of probate or New South Wales grant of resealing. But in the eyes of an English court, she would have had standing from the time of the deceased's death. There is, however, no doubt that English and Welsh law can diverge from that of New South Wales, on whether a person appointed as an executor by a New South Wales testator has acquired title to assets in the estate. Quoting Dicey, any property of the deceased, which at the time of his or her death is locally situate in England, vests automatically in his or her personal representative by virtue of an English grant. And over the page, the rest of this my lords have seen already from the extracts from Dicey. It appears to me, notwithstanding that the claimant obtained the grant of probate in New South Wales, it is from this jurisdiction that she derives her authority to collect assets here. After all, a foreign grant of representation is not without more recognised as having any force in England and Wales. That being so, the law of England and Wales is, I think, to be applied to the issue of whether the claimant acquired title to the deceased's estate on his death, and New South Wales law on the point is immaterial. On that footing, the Chetty and Chetty approach is in point. The claimant is to be regarded as having acquired title to the cause of action against the defendants on the deceased's death, and so as having had standing to issue the present claim when she did. And as I said earlier, if title to sue had been governed by the law of the domicile in Jennison, the claimant would have lacked title to sue. Her claim would have been struck out.
In Jennison, she had in fact obtained a grant from a New South Wales court before issuing proceedings in England.
Yes.
Why did that not confer sufficient title on her to sue in any event, regardless of the provisions of the New South Wales law, which said that until there was a grant of probate, it vested in the trustee?
Because the foreign grant, my lord, is not recognised as providing any authority in England. She requires, subject to Chetty and Chetty, she would require an English grant to be resealed. So that what happened, the treatment of the existence of probate or otherwise in New South Wales was, in my reading of my lord's judgment, immaterial. The question was, did she have title to sue in February 2019? And she had it from the moment of the decease, because she was named in the will as the executrix.
I think the punchline on this is probably paragraph 60. So
Yes.
you're back to the nullity point.
Yes. Sorry, I was coming to that. Perhaps I misunderstood your question. But
No, well, that does illustrate the question. I understand entirely the point that if you have no title when you issue, so that it is a nullity, you can't, later acquiring title, give life to something that was a nullity when it was started. I understand the point. that the only way in which you can prove your title in England is by resealing your grant. The chronology in Jennison was the death was in 2007. The grant in New South Wales was 2008. The proceedings were issued in February 2019, and then the grant was resealed in November 2019. So the only question was it when issued a nullity? And the fact that you didn't have an English grant in February 2019 didn't make it a nullity. It meant you weren't yet in a position to prove your title, but you could cure that by getting a resealing before you got to trial, which is what happened. My question is this: since in February 2019 the grant had been obtained in New South Wales, it doesn't matter whether the correct explanation is that the title in New South Wales on the Chetty and Chetty approach was to be treated as having vested on death, or whether the title in New South Wales was initially in the trustee and later, by virtue of the New South Wales grant, treated as relating back to the death, because by the time you get to February 2019, one way or the other, she does have title in New South Wales as executor, and that's sufficient to mean it's not a nullity. Maybe I've misunderstood the principle you're trying to get from the case.
My lord, that's a point that's never been. I mean, I'll have to look at that more closely.
I'm conscious it's my lord's judgment.
Naturally, my recollection is imperfect. I don't think anyone suggested that relation back saved anything.
I'm not going to speculate because that point has never come up at first instance or in the.
Yeah, I mean, it's unfair to expect you to explain a case in a way which it doesn't address. But what is the principle that you say we get from this case?
The principle is the principle which is already in Dicey, which is that for these matters, for the purposes of the claim in England, authority, title to sue is a question of English law, and because it's a matter of English law, she had title to sue from the moment of being named as the executor in the will. That was sufficient for the purpose of title to sue. The point that was been taken against her was that she lacked standing to sue, and the answer was it's governed by English laws, elects forum, and under our law she had title to sue. The fact that she apparently, perhaps wrongly, was said to have lacked title to sue in New South Wales was the point.
But why does not the same apply to the Brazilian heirs? Just like the claimant in Jennison, under the law of their domicile, title had vested. You couldn't, maybe you couldn't get to a judgment without getting a grant in England, but it doesn't make the proceedings a nullity when they're issued.
But the question is, for the purposes of for having title to sue to issue the proceedings without a grant, because these are representative proceedings, they are a nullity. And that really
why? Because
there's no authority to bring them, and
I don't understand.
From Milburn and Snell and from Jogi, they recognise that a claim issued in a representative capacity without a grant is a nullity. Unless potentially Rule 17.44 applies.
Well, no, but unless under Jennison you did have title from death under the Chetty and Chetty approach.
But that wasn't the approach in Jennison, my lord, unless I misunderstood. They didn't say
when she issued, she didn't have an English grant. That was the problem.
Yes.
But it didn't make it a nullity. Why not?
Because of the different approach that's taken to executors in wills and administrators.
And so the executor, their title vests on death.
Yes.
Why do the Brazilian heirs title not vest on death?
Because the question is, it's an English law question.
But it's the same question. I mean, there are no executors or administrators in Brazil. In Brazil, we know that the assets vest in the heirs on death. Now, you say they vest in the heirs in a representative capacity, and Mr. Cutrale says, no, they don't, they vest in an ownership capacity. But there's a different question, which is, were the proceedings as issued a nullity? Jennison illustrates that is not answered by saying you don't have an English grant on issue, because you can answer it by saying, I haven't got an English grant on issue, but I will get an English grant before trial. I've still got something which the English court will recognise as being capable of being cured by an English grant. Do you see the point I'm...
I see the point, my lord,
And,
but I think
so why is that not the same with the Brazilian heirs? Why can't they say, suppose we are representative, we still derive our title from death under the seizing principle. We, on this view, accept, I know Mr. Cutrale doesn't accept this, but on this view, we accept that we'll have to get an English grant before we get to trial, but it doesn't make our proceedings a nullity, so they can't be struck out.
the point of the answer, my lord, is the point I made before, which is that they are, when they were issued, because they had no grant and because they were representative proceedings, they were a nullity. And they were a nullity under our system. Proceedings issued without a grant, without more, are a nullity.
Can I just...
The position of executive is different. The position in
Why is
Jennison,
the position of an executive different?
because under English law, which is the law that applied to the administration, the gathering in of the assets, one asks, do you have a title by reference to the will? It's not the same when there's no will, and that's...
Your point, I think, is at a much higher level. Your point is, the question is, who has title to sue?
Yes.
And the answer is English law will tell you that.
Yes.
Peculiar facts in Jennison, but it's not the fact whether there happened to be somebody there who had it. The question is who under English law, and whether it's right or wrong, sensible or not sensible, under English law, it was the executor.
Yes.
New South Wales was different, surprisingly, but it was. And you say it's the same here. It's English law, and we, you say, don't treat an undifferentiated, non-yet distributed estate as giving rise to a title to sue.
Yes.
The fact that in Brazilian law, they would be able to sue, and they would eventually get a sharing document, isn't enough, you say, because that's not what English law says. That's your case, I think, isn't it?
And I'm very grateful for
Right.
that's put far better than I did. But that's, if I may respectfully adopt how my Lord Justice Lewis has put that, because that's the point. And that's why I took you to Dicey 158 and 159. In substance, the effect of what my Lord Justice Nugee is saying is that we would be taking the authority under Brazilian law as sufficient for these purposes. And that is the opposite of the approach.
Suppose Brazilian law said, on death, the assets vest in the heirs qua executors. Then why wouldn't they be analogous to an executor who derives their title from a will? We know they don't derive a title from a will, they derive a title from the law.
Again, I'm not going to give a definitive answer to that question because it's one we've not addressed, but and subject to how I'm corrected by a proper chancery lawyer sitting behind me, that would still have to be analysed through an English law lens. We would still have to ask as a matter of English law, is that in substance the distribution of rights finally and absolutely to the person claiming to have title to sue?
Can I try sort of framing this dispute in one way? You say, look, even looking at Brazilian law, we can see that we haven't got to the stage of distribution, therefore it's a question of administration, not succession. If it's a question of administration, you say, well, look at Dicey, you have to look at the law of England and Wales, not Brazilian law. So then you look at the law of England and Wales, and the law of England and Wales, in ordinary domestic terms, says you have to get a grant from the English court unless you're an executor. If you're an executor, then you have title from the start, but you can obtain confirmation of that later on. So a way of framing, I think, the discussion between my lord and you is, if we're looking at English law and trying to work out how it fits in this situation, can one equate the position of an executor with the position of an heir, so that applying English law, you end up saying, oh, okay, an heir can claim anyway.
Yes. Again, thank you. And to complete, if that's the question, which I think it is, then the answer is, applying English law principles, one cannot equate an executor with the position of an heir as found by the judge here, because the heir here has not received, distributed to him or her, the right absolutely and personally to pursue the claim. The heir has it in a representative capacity only for the purposes of the whole of the estate. And we'll come to that when we look at ground 3 if I have time. So, my lords, I'll move on, if I may, then, to High Commissioner for Pakistan and National Westminster Bank. And that's in the second volume of Authorities, tab 32.
Not that we'd all
Claim
that's my law bundle. They would always be put so close to the edge they would fall. Oh, that's big.
I think that's one's mine.
We can, at the short adjournment, I'm sure somebody can replace it. The ring binder is broken.
I think it's all right. Yeah.
Which tab are they?
Tab 32.
32.
And if you could go, please, to paragraph 22. The background to this case has already been explained to you. I'll just go straight to paragraph 22 on page 838. So, an heir of the deceased who is seeking to put himself forward first as a representative, and that was defined by Miss Justice Henderson at paragraph 23. And then if we go to 27, we see arguments which are very like the arguments which the claimants are making to my lords in this appeal. And I appreciate you can take this before, but we do rely on it. And we're a judge in this judgment, obviously a very experienced judge in these matters, and one could expect in my submission from him rather more succinct reasoning because of perhaps the obviousness of the points used to him. I also need to deal briefly with an argument advanced by Mr. Brown this morning that the Nawab, the heir, can claim directly against the fund in his position as an heir, assuming it to be established on the facts that he is an heir. The argument was, put briefly, that he would be able to rely on the Muslim personal law applicable to succession to the estate. The evidence indicates that his personal law would not recognise the concept of administration of an estate, and the relevant property would have vested automatically in his heirs. So the principle very likely. Therefore, the argument runs, there is no estate for an English personal representative to administer, and nothing to prevent the heir from making a direct claim to the relevant property. That argument, it seems to me, is not sustainable on the basis of authority which is both clear and binding on me. Under the English conflict of laws, the state administration of an estate is governed by the law of the place where the assets are situated, which in the current context means England. Procedural questions arising in administration are likewise dealt with by the law of the place where the administration is taking place. It is only when one gets onto the question of succession and who is entitled beneficially to share in the estate that one looks to the law of the domicile of the deceased, when one is concerned, as here, with personal property. And my own friend said, well, this is rather thin reasoning and no authority is cited. My Lord Justice Newey pointed out to him that that last part is taken from Dicey. And it is, just for your reference, that's Dicey, paragraph 27032. 29. The disputed fund is situated in this jurisdiction. That remains the case, regardless of how it may vest in accordance with the Muslim personal law of the deceased. The authorities establish that claims to property in this jurisdiction can only be advanced by and through a properly constituted person. 31. On the basis of the authorities and as a matter of principle, the argument advanced, which in my submission is the same argument advanced to you, my learned friend, is misconceived, does not provide an arguable basis for his client to claim directly in his alleged capacity as an heir. Apart from the brevity of the judgment, my own friends say, well, he didn't refer to Macmillan or Ephraim on characterization. A reference to those authorities in my submission made no difference. They only described the process of characterization. The learned judge in High Commission of Pakistan plainly characterized the issue before him correctly. Then they say, Mr. Justice Henderson failed to take account of Haji Ioannou and Vancalan, but the principles in those judgments, as I shall show you, are entirely consistent with what we have seen in Jennison and in the High Commissioner for Pakistan case. They found that succession, this is Mr. Justice Slade and Vancalan, they found that succession, as opposed to administration, had taken place because of features that were absent in Jennison and in the High Commission of Pakistan, and absent from this case. And I'll take you briefly first, if I may, to Haji Ioannou, in the second volume of Authorities behind tab 24. The question in this judgment was whether the applicants had succeeded to a judgment formally entered in favour of the deceased. And Mrs. Justice Slade found that they had succeeded once they had obtained a personal and exclusive right to it under the Lex Domicilii. And that didn't, just to summarise, that did not occur on the death of the deceased, but at a later date, when certain formal requirements were satisfied under the law of Monaco as a law of the domicile. So simply becoming an heir was not sufficient, contrary to what the claimants had submitted. You go to page 728, please. Paragraph 65. Second sentence. In my judgment, the evidence of monogamous law is to the effect that obtaining the status of heir, which is all the claimants have in our case, and acceptance of inheritance rights are two separate and distinct steps. An heir may not accept his inheritance rights. And skipping down to the last sentence in that paragraph, in my judgment, the applicants have not established that the acquisition by them of the status of heirs in itself confer the interest in the Frangos judgment required for its registration in accordance with Article 38. Now with the page, paragraph 68, page 729, I'm not satisfied that on the evidence before me that the applicants acquired an interest in the Frangos judgment on before 13th of January 2009. They acquired such an interest when they formally accepted their inheritance rights by the Acte de Notoriété in May 2009. This declared the applicable law, and then this, and the proportions of toute propriété de la succession immobilière de LH of each of the applicants. It appears here there had been a distribution, a sharing of the proportions of the estate. And at that point, the interest was acquired. If you go now, please, to Vancalan, that's in the second volume, Authorities behind tab 11. Sorry, same volume, tab 11. Since my Lord's eyesight is better than mine, you won't have been taxed reading this the way I have been. It is not easy to read, but when one analyzes it closely, one sees it does not support the case which the claimants have been putting to you. In summary, and you've seen this already, Mrs. von Calan's husband died, and under French law, she succeeded to all of his rights and liabilities. She paid off one debt, I'm paraphrasing, and that gave her a claim against the defendant, Bouar. She got judgment against Bouar in France. In her own name, she obtained judgment and sought to enforce the judgment in England. If you go please to page 463, and one sees the judgment of the Chief Justice Earl. Page, it begins just between the two hole punches on 463, and then go please over the page to 464. And I'll take the counts in turn. So, with the background that I've just outlined to the court, the plaintiff, with these rights which she inherited, in order to keep alive the liability of the defendant and to prevent the same from being barred by lapse of time, she took proceedings, this is after the death of her husband, in the French court and obtained an adjudication, an injunction made the defendants to pay a certain sum of money to her. And skipping down a couple of lines, that is the substance of the first count. The substance of the second count is that certain bills of exchange were drawn upon the defendant by the deceased, and after he died, the plaintiff was, according to the laws of France, the donee of the universality of the person and real estate belonging to the succession of the deceased, thereupon became entitled to all debts, and so on. And the same became and were, according to the said laws, and I rely on this, vested in the plaintiff personally and absolutely, in the same manner, to all intents and purposes, as they were vested in the deceased. And the plaintiff was entitled to demand and sue for the same in her own name and in her own right. Now, the grounds of demurrer begin 3 lines down from that. These arguments are opposed on the basis that she's really suing in a representative character and she hasn't got grounds of representation. And if you skip down to the about 4 lines, I am of that, this is about her acting in a representative capacity, and the Chief Justice says, I am of opinion that that averment, if it were necessary to stand upon it, must be taken to be true, and so it appears upon the record that the law of France, in which country all the parties are domiciled, will give her a lawful standing to sue there in her personal capacity. But it is not necessary to rest upon that. The first count shows that after the death of her husband, the plaintiff paid the amount due in respect to the bills, and that would give her the right to sue in the courts of France in her own name and in her own right, as indeed it would in this country also. So, supposing there, the point upon which my friend placed so much reliance appears to be obiter in this judgment. The Chief Justice is saying it would be correct if it were necessary to rely upon it, but it is not necessary to rest upon that, because on this first count, she had paid off the debt herself. She had a right to sue in her own name, and then she obtained judgment in France in her own name. These are events that took place after the death of her husband. And skipping down 4 lines here, the alleged cause of action is founded mainly upon what was done by the plaintiff after the death of her husband. There is a further answer to the demurrer to the first count, that the rights of the plaintiff were confirmed by the French court, which entitled her to execution against the defendant in that country. It's abundant on the first count to show that the plaintiff had a good cause of action against the defendant in her individual capacity without having recourse to the special matter before averted to. So it appears that on the first count alone, Mrs. Van Calan's got home, but then the judge goes on to address the second. It's clear the plaintiff took the bills on the death of her husband, and if nothing more appeared, she could only enforce them here by clothing herself with a character of a representative. But the law of the domicile attaches these parties, and so they look, as the judge did, at, in the alternative, at Brazilian law and what the heirs actually got here. In Mrs. Vangeland's case, the judge found that the law vested in the property vested in the plaintiff personally and absolutely in the same manner to all intents and purposes as they were vested in the deceased. The plaintiff was entitled to demand and sue in her own name and in her own right. And it goes on to emphasize in her own name and her own right. And I think it sufficiently appears upon this record the plaintiff was entitled to sue upon these bills in her own right. The fact of her being the donee of the universality of the personal real estates belonging to the succession of her deceased husband, giving her by the law of France rights different from those which an executor or administrator has in this country. And there was uncontested French law evidence. We'll see that it was uncontested, that she had succeeded to the claim in her own right and for her own exclusive benefit and not as a representative. If you go to the judgment of Justice Williams on page 466, on the first count, this is halfway down 466. I think our judgment on the demurrer ought to be for the plaintiff. I do not consider that in so holding, the court will be departing or diminishing the effect of the rule which has been established by a long series of cases, that in order to entitle a party to sue in any court in this country, he must show he has obtained probate or letters of administration from the proper court of this country. And skipping down to below the second hole punch, Ms. Justice Williams refers to their author that the rule does not apply unless the party is suing in right of the deceased. The question is the person suing in right of the deceased? Applying those principles to the first count appears to me to plain the right which the plaintiff there is seeking to enforce is not a right which the deceased ever had. It wasn't a personal right which formed part of his estate at the time of his death, a right which was acquired by the plaintiff herself since her husband's death, the right which was compounded by a payment made by her and a judgment obtained by her. The right, therefore, which she seeks to enforce is not one which is ever vested in the deceased or which formed or could form part of his estate, but a right which the plaintiff herself had acquired, and she was entitled to assert in her own name and her own individual capacity. Then at the bottom of page 466, moving on to the second count, he has some difficulty. He's concerned, if you turn over the page, that this might be getting around the important rule in England, that if the claim is a representative in nature, grants of representation are required. But he is persuaded by his brethren that the position under French law is sufficiently clear, and that you see that halfway down between the two hole punches on page 467. And then Ms. Justice Keating finally agrees, and just at the second hole punch, she makes the point, I agree with my lord, second count does sufficiently show upon the face of it that, according to the law of France, so they're addressing a French law question here, they've looked at French law evidence, these are findings of fact based on the evidence before them. The plaintiff was entitled in France to this succession and to sue in respect of it in her own name and in her own right. And then this, it seems to me that it is alleged in the count with sufficient distinctness and that it is admitted by the demurrer. So that absolute and exclusive right which the plaintiff is said to have under French law was sufficiently clear and admitted by the demurrer. So one sees there what actually motivated the court in Vauquelin. If it were authority for the much broader and bolder submission which our friends make, we would have seen this case cited many, many more times in support of a very different proposition, in view of the fact that the principle of Cezine is, in its common ground, very common across the civilian jurisdictions of the world. And all these principles that we see in the authorities were faithfully applied in the judgment itself. And if you go to it, please, in the core bundle, behind tab 15, page 241.
Actually, it's quite difficult, isn't it? It's difficult to see quite what the difference is here. Does it turn, do you say, on the fact that there's two parts, you can sue and entitled to the succession absolutely, it seems the hardest case for you to get over. Anyway, you want to show us what the judge said?
I mean, Von Calan, my lord.
Yes, you want to show us now what the judge said about Von
Yes, I'll show you what the judge said compendiously, because the judge has to deal with it. But on Von Calan, you have my first point, which is that that whole analysis under the second count may be obiter, because
Yeah, second count is fine, yes.
because all she needed was to win on the first count. She was
Is
seeking
that
to-
right?
But hang on,
They're two separate counts.
Sorry, I must have made a mistake. Then she was
But
seeking,
the first count is where she has out of her own pocket paid the bill,
yes,
and so she personally acquires a right against the defendant.
Yes.
We're not concerned with that. The second count is bringing a claim on a claim which her husband had had when he was alive. So you do need to succeed on the second count.
yes,
And the answer that the court gave was, look at the law of France. Under the law of France, she's not bringing that as a representative of her husband, she's bringing that in her own right.
indeed. My lord, yes, and I'm sorry, my lord's quite right. And there, in that respect, they took a view of what the French law said, and it was admitted that it gave her, she had succeeded. It was an issue of succession, and she had succeeded. That was the finding. The finding there, applying French law, was that she had herself succeeded to the rights and was no longer suing in a representative capacity, but exclusively for her own benefit. And that's the finding of French law, which we do not see that here. The law of Brazil is different, and the judge made different findings in respect of it.
So it does turn on the distinction between bringing a claim in your own right and bringing a claim as a representative.
Yes, the question is, what is the nature of the claim, and if it's brought as a matter of substance as a representative claim, however it's labelled in the foreign jurisdiction, that's the key question. The judgment begins at page 241, from paragraph, it begins there, but I'll go straight to 167 if I may, where you see our submissions and the claimant's submissions are 168. And skipping ahead, the discussion begins at 169. I'll move rather quickly through these, my lords, because you've read the judgment and time is short. But just to show, my lords, that the judge did consider these authorities and apply the proper principles found within them. She looked at Jennison and Pakistan, and we see that from 174 to 175. And if you go on, please, to 179, she did note that the argument in Pakistan was very similar to that made in the present case. She relied in detail on what Mr. Henderson said in High Commission of Pakistan, following her citation of what my lord said in Jennison. And she rejected the claimant's attempts to distinguish the High Commission of Pakistan case. And if you go over the page from paragraph 182, you see that. And at 183, she notes the submissions for the defendant and the claimant. And she, just to read back to you what she quoted from our submissions, you have to ask, as a matter of English law in this court, if the heirs have succeeded to the assets in the sense understood in this jurisdiction. And that's what High Commission of Pakistan demonstrates. And that is not what has happened according to the principle of Cizé. And she takes that from 185. She quotes from Cheshire North, paragraph 186, which distinguishes between succession and administration. Those are passages relied upon by her own friends. 187 on the page.
Well, is that right? I thought you relied on the latter part of 186, the quotation of 186.
Oh, indeed, my lord. I simply say that my own friends have cited that text. We haven't taken you
Oh, I see.
to it, but you're quite right, my lord. We relied on this, and she adopted it.
Yep.
Paragraph 186 of her judgment. I hesitate to waste your time. The court can read for
Yes,
yourself
yes.
What's underlined in paragraph 186. 187. We submitted succession as a matter of English law revolves around the distribution of specific assets to specific beneficiaries. And succession takes place when those assets, and this point perhaps I should have emphasized more, succession takes place when the assets cease to form part of the deceased person's estate and form part of the beneficiary's personal estate. 189 and 190, again, the judge quotes from Cheshire and North. 191, she cites Haji Newey and Montcalin and Boer. She quotes from Montcalin from paragraph 194 to 195.
And again, we've gone over this, but just as clear in my own mind, it's clearer when you see the wording. There was a distinct averment, whatever that means, a distinct assertion that she had become entitled to, the money had been passed over to her, if you like. What we've been calling distribution had occurred. That seems to be the aversion. And they were prepared to accept it out of her sympathy for Mrs. Bacalan.
Yes, it was admitted. You're quite right. I was trying to, that was the point I was trying to make to my lord on Montcalin, when he quite rightly picked me up on the fact that the two counts were dealing with two different points.
Yeah.
But quite absolutely, the court found on the French law before it that
But
the
it
assets,
found on the admission, whatever the demurrer is, I think.
the admission of the demurrer.
It's the demurrer, that the fact that it's admitted by the parties, I don't know what demurrer is, but that's what it seems to be saying, is that they've sold the past, effectively.
The demurrer, I think the demurrer is the opponent or the respondent to the
Yeah.
application or whatever it was, opposing the claim. But yes, they had sold the past. They had agreed that
It was hers now,
it was
absolutely.
hers now. It was no longer the deceased's estate. It was in her
It's
estate,
hers, yeah.
her personal estate. And so therefore succession had taken place. It had been
I think
distributed.
strictly speaking, they haven't accepted it, but the demurrer is argued on the assumption that the plea is true. If you look at the very end of the report, there's a suggestion by the defendant that they're going to amend to say, actually, the law of France is different. In other words, demurrer is like a strikeout on a point of law,
Yes.
without accepting that the allegations are actually true, but on the assumption that they are.
I overstated, my lord. You're quite right. And I have checked to see what happened to this. It's a curious case, and considering the emphasis placed upon it, one would expect it to be more important. So we have done quite a lot of research around it, and I couldn't cast any further light on what happened to
It doesn't matter because you're saying on the assumption was that everything, we'd not just had the right to sue and recovery of the estate, you're here saying that on what they proceeded on, the money had passed from the estate to her own purse or pocket.
Precisely, my lord, yes. And that's why Miss Justice Williams, and especially Miss Justice Williams, was reassured. Because it looked to him initially as if it really did seek to evade the rules on representation, but he was reassured because of the very point my lord has put to him. In my lady's judgment, she quoted from Montcalin, paragraphs 194, and the reliance placed upon it in Cheshire and North. And if you go on to read from 196 to 199, you have her conclusion. 199 being in the alternative. And paragraph 199 is the distinction, well, it's how she approached this alternative case, which I tried to summarize this morning. And so I'd ask you to read 196 to 199, please.
Yeah. Yes.
Well, I'll move on then to the claimants' submissions in response. They first challenged how the judge approached characterization. You have my submission as to how characterization is properly approached, we say the distinction she drew between administration and succession in examining the connecting factors was unimpeachable. And the claimant's reference to taking a more internationalist approach or one without bias towards England is extremely unclear. It's extremely unclear as to what they actually required her to do or what they say is the principle. It appears to us simply to be an invitation to apply Brazilian law because it is the governing law of the underlying claims. But the issue is whether title to sue in England, the issue is whether there is title to sue in England in respect of claims situated here for loss and damage suffered by a deceased person. And to the extent that it was necessary to respect comity, the judge did so because she carefully examined how Brazilian law treated the claimant's rights, and she distinguished between what is a Brazilian law issue and what is an English law issue. The claimant's second point is that the Sazine principle is succession under English law. But there is no dispute that what constitutes succession under English law, the lex situs, is the point at which the claim is transferred to the claimant absolutely and for his or her personal and exclusive benefit after the process of administration is complete. And that means the claim is owned by him or her and only by him or her, and that only he or she can take the benefit of any judgment in his or her favour. And the judge found, relying on the claimant's own expert evidence, that that is not what happens, applying the Sazine principle in Brazilian law. Even if an heir, prior to the sharing recorded in the Formal de Partilha, can bring a claim for loss and damage suffered by the deceased, he does so for the benefit of all of his co-heirs and with absolutely no personal entitlement to any part of the recovery. And such a claim is part of the administration of the estate in the sense that, when Order of Justice was put to me, the harvest goes into the common pot and the harvest is sold to pay off the king and the taxpayers and whoever else has to be paid off, and what's left is distributed to the heirs. The heir who brought the claim may ultimately not receive anything at all in his own personal exclusive right. The claimant's third point is that Brazilian law should apply to this question because it's the lex domicili or the lex causae. And for this, we need to look at the claimant's skeleton itself to understand it. It's in the core bundle behind tab 11. And we hopefully can skip through these quickly. Paragraph 50, please, on page 97. Page 97, paragraph 50. First, 50.1, they say the claims, these claims, are not situated in England. They suggest that they may only have been situated in England when the first defendant was domiciled here, and the claims were not situated in England before he could be said to be domiciled here. But the situs of the claims does not depend on when the claimants came to England. And once the claims were brought here, the chosen action was reduced into possession in England. And that is as clear as day. Just for your reference, that's Lord Denning in Trendex Trading, volume 2 of the Authorities, tab 16, page 549 at F. Then 50.2, in the context of an action in court against multinational businessmen, who could easily move from one jurisdiction to another, cause of action may be said to be situated in many different jurisdictions at once. But once again, that may be, but once the claim is brought here, once it's a claim, it can be brought here and is brought here, it is situated here. But the key point is you can't rely on actual or possible claims in other jurisdictions to argue that the claim which is being brought in England is somehow situated in some other jurisdiction. It doesn't make any sense. 50.3, if notwithstanding the above, the deceased person's litigation rights are to be treated as situated in England, that has the perverse result that upon death, as a matter of English law, the rights vested in the English public trustee, despite the fact that they have no connection with England or any other assets here, the deceased person. Their Brazilian claims arising out of things that happened in Brazil. And taking those in turn, true it is the claim is vested in the public trustee, but only until the grant of representation is made.
Just to be clear, they're only vested in the public trustee once they're reduced to possession on your case, once they're brought.
Yes, and even then, my key point here is that the public trustee doesn't get any beneficial interest in the claims. The suggestion is that it's some intrusion or some conflict with rights in Brazil. It's a formal and protective role, where really the main thing is that they must be notified before a grant of representation is made. The fact that the bulk of the estate may be outside England doesn't affect the analysis. Well established, even if that's the case, a grant of representation is still needed for assets situated here. The claimants then say the judge's finding the claims are situated in England cannot be reconciled with their finding that once the formal de partie is issued, the claim can sue in its personal and absolute right. But that's the same point that was made and addressed in Jennison. And we fully accept that once the claim has been transferred into the exclusive personal possession of the claimant in Brazil with the formal de partie, there is succession to the asset. And the Brazilian law then applies to matters relating to succession. But that doesn't move the claim to Brazil. Since we're focused here on where the claim is situated, the claim in the English courts is still situated here. The claim in skeleton in paragraph 51, they seek to distinguish the other cases, Jennison and High Commission of Pakistan, on the basis they concern to assets unquestionably situated in England. I'll move quickly over that. A claim for damages is admitted to be a choice of action. It's in England and reduced to possession here. That it can hardly be clear where the asset is situated in those circumstances. Paragraph 53 of the claim in skeleton, they go on to say that Brazilian law should be applied as the lex causae. And they make this point based on analogy with assignment. They say, 4 lines down, there's a close analogy between the transfer of litigation rights by operation of law upon the death of the original right holder and the transfer of such rights by other legal means such as assignment. But that doesn't work either, because assignment involves a transfer by the assignor of the beneficial interest of an individual asset to the assignee alone. So the assignee, in fact, has personal and exclusive ownership of the asset represented by the claim. It's no longer an asset in the deceased's estate, it is only an asset in the estate of the assignee. And that is precisely what Cezine is not. According to Professor Schenk, the claimant's own expert, Cezine principle, and we'll come to this in ground 3, is a legal mechanism under Brazilian law by which the assets of the deceased person are treated as an indivisible whole to all the heirs of the deceased person. And until the issue of the formal de partie, no beneficial interest in any individual asset is transferred to anyone.
Is that going to be a convenient moment?
It is, my lord, thank you.
I'm afraid you were right in anticipating that I had destroyed my file. If anyone were able to put the documents into a new file, I'd be very grateful. 2 o'clock.
Round 2.